This person has been filed challenging proceeding initiated under Section 5(1) of the OAR Act, which has been initiated after 60 years of wasting.
Yes, land acquisition, madam.
Lease case are initiated without complying Forest Right Act.
Yes, land acquisition.
Appeal bail, madam. Already 12 were in custody, other co-active person. Give it.
Criminal for bail, my lord, nearly about 10 years in self-custody.
Now, for bail, I have filed the I that has been added to screen rule, but not this.
Yes, in heat appeal, madam. Already heard by the judge, Chief Justice, madam, already. When judgment is up, hearing also judgment is up, but that has not been brought out is given. Heat appeal is already there. Item 4 pointed to.
There is a lease matter.
Let's see, I may be pardoned to mention, I am on virtual. Let's see.
When counsel for the petition files and then withdraw the petition. Memo is taken on record. The petition is disposed of. Item number 3. Yes.
Let's see, I may be pardoned to mention, it is a public interest litigation pertaining to the clearance from the Coastal Aquaculture Authority, Chennai, to the prawn cultivators across Orissa, Lordship. This matter is a court monitor PIL, Lordship, taken up in the urgent basis, Lordship. I am submitting the hard copy of the memo.
PIL matter, why are you mentioning here?
Lordship, there was a direction by the Honorable Court, list it after 2 weeks. The cultivators, they are facing problem because the Coastal Aquaculture Authority, Chennai, they are not permitting, even though there is a direction to that effect.
All right. You mentioned tomorrow before the regular.
Lordship, as your Lordship, please.
Weekly list item number 1.
Yes. Your Lordship, I am appearing on behalf of Mr. We have no instruction. Your Lordship, please grant us liberty to approach this Honorable Court if the cause of action survives. What is your good name? We are filing this civil review petition against the regularization of cheaper consumption. They know the district. How the listing on the subject? No, sir, the upload draft will change and details were listed. Question code serial number 6. Out of all this, have you got power in this case? No. What is your good name? Siddhant Chandan. Siddhant Chandan. Mr. Siddhant Chandan, Land Counsel, appearing for Rahul Kumar Ratho and Senior Advocate, submits that he has no instruction in the matter. In view of such a submission, the review petition is disposed of. That's not disposed of that.
Yes, upon challenging
The review petition has been filed challenging the order review petition. Order dated order dated 5/11/2019 passed in the writ appeal number 60 of 2019, which has confirmed the order dated 16/5/2019 passed in WPC number 8948 of 2017. Yes. Your Lordship, please grant us liberty to approach this Honorable Court in the cause of action
No, you look at your prayer in your review petition. The review had not maintainable. You just asked for issuing notice and taking up the writ appeal afresh. What is the meaning of that?
In fact, the read petition, the order that was passed, that was in your favor. We do not know why the writ appeal has been filed and again review petition is filed. Have you gone through the brief? You have no instruction on the matter. Read petition order was passed that 16/5/2019, the last operating paragraph, considering the contention raised by the learned counsel for the parties, this court disposes of the writ petition directing the opposite party to consider the case of the petitioner for regularization of his service if he has at least 10 years of service on daily wage. So that was the order, right? See the writ petition. What is his case? Writ petition Bharat.
Appeal order भी नहीं.
Writ petition item number 1 को असो. Writ appeal को असो. Writ appeal follow. Now you see the writ petition, that is annexure 2.
Writ petition तो
Writ petition annexure 2, come to paragraph number 3. Paragraph number 3. Writ petition अच्छी अपन पाए. Come to paragraph number 3. What has been written there?
The petitioner engaged as super companion on daily wage basis under opposite party number 2 since 2014.
So 2014 ରୁ ସେ engage ହେଲା. ଆପଣଙ୍କର ସିଏ ଆସିଥିଲା ରିଟ୍ ପିଟିସନ ରେ କୁହାଯାଇଥିଲା ଯଦି ତାର 10 ବର୍ଷ ହୋଇଥିବ ତାହେଲେ ତାର ରେଗୁଲାରାଇଜ କରିବ. ସେ ଅର୍ଡର ଟା କାହା ଫେଭର ରେ ଗଲା? ଅର୍ଡର ଟା ପିଟିସନର ଫେଭର ରେ ଗଲା ନା ବ୍ୟାଙ୍କ ଫେଭର ରେ ଗଲା? କାରଣ ସେ ତ 10 ବର୍ଷ ତାକୁ ହେଇନି. ତାକୁ ଚ୍ୟାଲେଞ୍ଜ କରୁଥିଲେ କଣ ପାଇଁ? ରିଟ୍ ଅପିଲ ତାପରେ ରିଭ୍ୟୁ.
I understand.
नहीं 2014 ପରେ ତା ଗଭର୍ନମେंट ରିଟ୍ ପିଟିସନ since 2014. Yes, next.
Item 2. Item 3.
This is the matter. For Lordship, I want to take your Lordship to the last order, that is 27/1/2025. This is the matter.
What is that affidavit which has been filed by OP3?
OP3 at the Class X. The state government, your Lordship has pointed out whether as per the.
No, why the affidavit has been filed in pursuance of this court's order or what?
Yes, sir.
So, come to that order where you are asked to file the affidavit. Okay, that is the order dated 13/1/25. Here is 2025 order ta padham. Here padham. As per the order dated 17/12/2024. It would be pertinent to the section UC of the Orissa Government of Protect and Private Section of Organization Act as whether the land pertaining to the Khata number 343, plot number 41 of Moses and Sundarpur has been declared to be forest land by notification of the state government. Learned Council for State took some time to obtain legal instruction at the state. The Learned Council State submitted that he has obtained the instruction that there is no such notification issued by the state government declaring Khata number such and such Moses and Sundarpur to be a forest land. The Council for the State filed an affidavit that respected by a competent officer of the government.
Let this matter in the week commencing, from 27-25, copy of the affidavit be handed over the council of petition.
So the first detailed order was passed on 28/10/24. Right. Come to that order. 28/10/2024 order पर.
Pursuant to the order dated to 28
No. 28/10/2024 order person.
The Prasanna Kumar Ratho and counsel and his associate has filed power on their petitioner which taken on record. The petition has been filed by the petitioner challenging order dated 21/6/24 by the additional district magistrate Windsor in revision case number 1 of 1997. When it has been observed as follows. In view of the above, I am satisfied that the revisional court has initiated the show motor revision case on the basis of the material irregularity and the order passed on dated 37/1998 is within the 14 years of sanction of lease. Though the appellants purchased the land subsequently and are over possession of the same, the claim of the petitioners over the land and the lease was granted to the lessee for the
गोटे skip करिए उधर अपन. The claim of the petitioners over
the land cannot be accepted as the land was leasehold and the lease was granted to the lessee for the purpose of agriculture. This has been rightly cancelled by the revisional authority. Also, in many instances, the Honorable High Court have observed that the right in law exists only and when it is lawful origin and if an initial stage is bad in law, then all further proceeding consequent thereto will be non-nest and have to be necessarily set aside. The revisional authority was right while passing the order dated 37/1998 in revision case number 1 of 1997 and the grounds taken by the present petitioner has no merit and is hereby rejected. Accordingly, sanction of lease and land cancelled, revision case disposed of.
These are the observation of the ADM. Now you read out.
The London Council for the petitioner submits that the London ADM Windsor has considered the revision case number 1 of 1997 and found that the lease suffers from different defects. Inter alia classification of land in the Sabik Arwar is Kochilabana, which means that it was forest land. But the Tahsildar 23/7/1989 has mentioned in the order sheet that the classification has been changed from Kochilabana to Punapatita by the mutation case proceeding number 3020 of 1989 and ROR has been accordingly corrected. As per the Forest Conservation Act 1980, the Tahsildar is not competent to sanction the forest land without obtaining ownership from the Government of India. It is the contention of the London Council for the petitioner that there is nothing in the Forest Conservation Act that Kochilavana comes within the forest land. London Council for the State seeks some time to obtain instruction in that respect. Let this matter we commencing from 11/2024. Pick up your order.
Yes. So these are the grounds on which the ADM dealt with that revision case and disposed of. Okay. So admittedly, your affidavit shows that that was not declared as forest land. You come to your affidavit, which has been filed by opposite party number 3.
The annexure A/3 Meghalaya glass.
A/3, yes.
The Division of Forest Officer Chandra Wildlife. Complaints of order dated 2010-2024 and 13/1/2025 in the such and such. Sir, inviting reference to the above cited letter on the person subject, this is to inform you that plot number 41, Khata number 343, Mauda Samsundarpur under Bhubaneswar Tahsil has not been declared as forest lands by notification under section 2C of the Odisha Communal Forest Private Land Prohibition of Alienation Act 1940. Further, any recorded forest in revenue or forest record may be treated as forest as per the direction of the Honorable Apex Court in India WPC 202/1998 TN Godavaran Tirumpura versus Union of India. So there in the TN Godavaran it was expanded the provision.
You got the decision of T.N. Godavaram?
Yes. Utte parichite. For information, PIL discussion with regard to transit cutting
କୋଉଟା ବିଷୟରେ କହୁଛନ୍ତି? About what?
ଗୋଦାବରୀ case ରେ।
ହଁ।
ତ ଗୋଟେ କପି ଡାଉନଲୋଡ କରିଛି।
ହେଲେ କୋଉ ଡେଟ୍ ର ଅର୍ଡର ଟା?
ଓଲ୍ଡ ଡ଼ିସିସନ।
ଦିଅନ୍ତୁ ଦିଅନ୍ତୁ। ଦେଖିବା ନହେଲେ ଗୋଟେ କପି ଆଣିବା। ଦୁଶୁନି ଏଇଟା କଣ?
No.
ମ୍ୟାଗ୍ନିଫାଇଂ ଗ୍ଲାସ୍ ସହିତ ଗୋଟେ ଦେବେ।
ନଥିଲା
ନା ମୁଁ ଏଇଟା ଟିକେ ଏନଲାର୍ଜ କରି କରିଦେଇଥିଲେ ହେଇଥାନ୍ତା।
ଏଠି ଅଛି ଆପଣଙ୍କର ନେଟରେ ଅଛି। ନେଟରେ ଅଛି।
Find out this follow copy and
ଖାଲି lordship for information keep in mind that deforestation happening will what are the disputed fault and the Supreme Court said observe that since there is no direction or there is no notification, so steps may be taken with the government to as your lordship pointed out to see.
No, the region has been assigned by the ADM. You are challenging the order of the ADM.
Yes.
So you have to satisfy that how the ADM order is faulty or it is illegal. The ADM has assigned some reasons and stated that how it is proper. So 4 regions we have extracted from that observation which has been made by the ADM. So which ground according to you is not legally sustainable? Any of these grounds according to you?
4 questions in course of the argument also on the second day come to conclusion that first question whether land is forest or not. If the land is forest,
even if it is not declared as a forest land, you just now see that notification and what has been stated there. What has been stated in that annexure A by 3? Have you got a copy of that?
Yes.
So what is
A by
there?
3. A by 3 they rely there is no absolutely there is no notification. As per section 2C of the Odisha.
This is to inform you so that it has not been right. Further, any recorded forest in revenue or forest record may be treated as forest as per the direction of the so and so. So does it mean that it is to be, there should be a declaration always, otherwise it cannot be said to be?
No, my lord, because 2C came into existence. It's an abstract.
No, that
2C of
is why we are asking you for the decision in T.N. Godavaram so that we can be clear.
I will prepare the
Mr. Because suppose this is not been declared as the forest land, that makes very clear because of your affidavit. So now if you are relying on this annexure A by 3, in paragraph number 3, what have you stated in the annexure? That affidavit.
That DFO has stated that, but while giving your affidavit, you have not brought to the notice of the court about the decision of T.N. Godavaram.
Next week I will.
You're understanding?
The
DFO has informed that it has not been declared as a forest under so and so, but as per the decision in T.N. Godavaram, any land recorded as forest in the revenue records will be treated as forest.
Examine and.
But that you have not brought to the notice of the court in your affidavit, which it was the duty of that Tahsildar or whoever has done it.
Okay. Whether that land, whatever you have mentioned that this is the in that decision of the Honorable Supreme Court, this has been stated. So whether this particular land also
within the
that is plain and simple. That is not there in the affidavit.
One add Act is 48. Judgment is 1956. After judgment, what they have done? Judgment is Supreme Court or Lordship passing. Keep the government.
Forest of Ratho jungle, other jungles is also forest land.
In spite of Honorable Supreme Court judgment, also they are not carrying.
On T.N. Godavaram.
The Land Council for the state submitted that even though an affidavit has been filed personally talk to that man properly. Has been opposite party number 3, additional Tahsildar, has filed an affidavit in pursuance of the order dated 13/1/2025, but annexing A by 3, which is an order passed by the clarification question of the of the DFO, Chandaka Wildlife Division and Bhubaneswar. He seeks some time to file a better affidavit during course of this week or next week. Next week. Next week. Put up this matter. You have filed the counter affidavit?
No, the counter
counter affidavit file कर दियंतु ये अधा अधा
ठीक है कौन भी कर दियंतु स्वांसो कर दियंतु मतलब पेरियु दी स्वांसो कर दियंतु तापर एटा लिखि देबा he intends to file and the counter affidavit issue notice on the question of admission indicating that the matter shall be disposed of for the stage of admission. Land Council for the state accepts notice on behalf of all the opposite party. Extra copy of the writ petition be served on so and so. Matter be listed on such and such. Yes, next.
Item 5.
Demolition extra.
Next.
Item 5.
Item 5, yes.
My lord, I am for the petitioner. I have challenged this order of opposite party number 2, annexure 1, past gross violation of the competent authority.
I pray for next week only for file this. He has affidavit received last week. Pursuant to the order of this honorable court, he has filed the affidavit along with supported documents. Discussion of
Next week already handed over the relevant documents with affidavit to this form for a short. Document has been handed over on this form. So you have not received the instruction on that. The Land Council for the state submitted that they seek some further time to obtain instruction on the documents with affidavit which has been filed by the Land Council for the petitioner as per the order dated 15/1/2025. Put up this matter next week.
one
On the so keep it on.
Item 6.
four occasion time has been shown.
But he has sought for time. It's not that he was absent and all of it. So he was present and sought for time. So we are passing it over.
Item 7.
Yes, your lordship's order dated 10/12/2024, my lord. The distribution company has moved to Honorable Supreme Court, my lord. The Supreme Court has in the meantime was used to entertain the petition saying that I'm supplying the same in shape of memo, your lordship. The Honorable Supreme Court has not interfered with the
Yes.
order
Interfered with.
and has to deposit that amount.
Yes, we have deposited.
Where is that document? Hey. I think what on
I'm supplying the copy of the order of honorable assessed also. The receipt towards the payment of the contingent amount as per direction. And honorable assessed court
amount to
directed
deposit for the event?
not to deal with the matter, deal with the amount by the collector. And I need time to file a detailed counter affidavit.
Just a minute. You are for?
And for 3 to 5 years. Okay, 3 to 5. The distribution license.
Mr. Amitabh Das, one senior advocate for the petitioner, one counsel for the state, as well as P number 3 and 4.
My OP 3, 4 and 5.
That is 5.
3 to 5.
Which are consolidated. And one counsel hearing for the opposite party number 3 to 5. It is brought to our notice by the land council for the opposite party number 3 to 5 that's against the order dated 10/12/2024. This court they approached the Honorable Supreme Court in so and so case number. And by the order dated 10/1/2025, the Honorable dismissed the special writ petition. However, an observation has been given that the collector shall not deal with the amount so directed in the impugned order to be deposited by the opposite parties number 3 to 5. And such order shall be subject to the final order to be passed in this writ petition. The order passed by the Honorable Supreme Court is taken in record. The land counsel for the opposite party number 3 to 5 has filed a memo to the bank draft.
But it's check
of the amount of rupees 2,09,464, which has been deposited opposite party number 2, that is the collector from District Magistrate Balangir on 27/2025
27/1/2020
memo along with the documents filed are taken on record. The land council in this matter notice has been issued.
Yes, madam.
Let us see that.
No, only prayer is look, the compensation amount has been determined. The TPD or WDL or the party, the market value was determined, and thereafter, my lord, they were directed to deposit the 2% contingent amount.
He wants to file a counter affidavit, so getting filed some notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land counsel for the state accepts notice on behalf of opposite parties number 1 and 2. Copy of the extra copy of the writ petition be served on the land counsel for this also. Land counsel for the opposite party number 3 to 5 6 some time to file the counter affidavit of this matter. Date will be March 1st. 3rd of March 2025. Counter affidavit can be filed in the meantime. Data taken on record.
Item 8.
Well, so nothing allow me some more time to produce the certified copy of the judgment and decree of the court below, as per your lordship's order. Because the
Which order we passed?
first order you ordered
212.
212, my lord.
Come to that operative. Let the operative parties at page number 3. Let the land counsel for the petitioners file the copy of the plaint and decree passing the title suit number 31 of 1994 in the Court of Land Civil Judge Senior Division Board. To also the copy of the appeal memo entitled appeal number so and so. So you have already taken adjournment.
Yes, my lord. I have
Two
taken 2
times.
adjournments. The difficulty is my record is not available in both. Most likely it is available in Silveri. And I am asking for it. Your lordship may allow me some more time.
The land counsel for the petitioners seeks some more time to comply the order dated 2/12/2024. Put of this matter.
How much time you say?
2
Some
weeks,
time
2 weeks,
again
my
you
lord.
ask for time.
2 weeks, my lord, your lordship. That will suffice.
2/12/2024 2 मास ହେଇଗଲା।
I guess you.
প্রথমে আমরা ଅଧିକା ଟିକେ ଦେଇଦେବା
ଅଧିକ ଦେଇଦେଲ।
10 ତାରିଖ 10th March।
Aaj your lordship.
Item 9.
Please, my lord. My lord, here the petition is belongs to scheduled caste community and also landless person.
You have got no power in this case, Mr.
Now, on behalf of Mr. Proraj, I am appealing.
Fine.
Mr. Proraj. Sir, my representation is pending by the Annexure 2, my lord. The opposite party number.
What representation?
Annexure 2,
Annexure 2 is a representation.
sir.
Annexure 2 is the ROR.
Annexure 2 you have
Sir,
mentioned page 17 to 19.
Sir.
So
No,
very-
PLA Act would have gone. PLA Act something. Sorry, not our ROR also.
Page 20, sir. Page 20, the form is there.
On 20 no. Just a minute.
Sir, sir.
20 कोड ଆସିଲା?
Page 20 only.
20 तो पेज ही नहीं। 20 is your वकालतनामा। वो फाइल टा को दक्षिण Page 20 is your
Sir,
वकालतनामा।
Sir. My lord, it will be taken up next week. Now, see,
କଣ ହେଲା?
Sir, it will be taken up next week.
Land counsel for the petitioner is for an adjournment.
Huh? Now,
Yes, next.
sir.
Item 10.
As per your lordship, a cited one decision. AIR 2020 Supreme Court 5 and 5. So that is no lordship we hold that if cut-off date is
2010, I will case maintain. But that case is applicable Gopal Group after. To that extent, I have called for certain information from my client, and my client has applied for MCA, but it is cut off. My client has not supplied. I need some time, but my client has applied on PI before the MCA.
You want adjournment?
Well, Lordship query in this case.
कौन PIL कौन हम किसी बुझियो
PI नहीं तो
कौन कहले lordship head
query certain regarding cut off date. What happened in the land of the petitioner?
copy मांगेले कोठे से cut off
Have you submitted a legible copy of that?
No, that matter is over. Copy दे दी.
कोठे मांग
That
Right, देखिए.
order citation दे दी.
order कोठ किछ नहीं order खाली अच्छी legible copy दियो तापर से time मांगेले
हाँ, मैं legible.
lordship पे जाके कौन दी सब पढ़ी
Except
ये की कोठ है
all second side will difference, like the kind of thing. In advance, legible.
legible copy उड़े दे चंदी
That so that has not been reflected for us.
no but see जोड़ा कोठ order
Okay,
कोठ
one case, Mahanadi Coalfield versus Marquis Sora. वो side cut थी. तेरे उड़ा cut off day 22 और 22.
No, there is nothing has been reflected in that order. Whatever it may be, you want adjournment, we are granting you adjournment. That's all right. So,
on the adjournment लिखे थे you want an adjournment for
certain document information from my client.
all right.
Let's go to our
Land counsel for the petitioner submits that he has already filed the legible copy of Annexure 7. Stop. However, he submits that he wants to obtain some instruction from his client, and the matter may be taken up next week or a week after.
week
A week
at March 1st. We can see the IMC apply ko
after. 2 weeks after. As
March 1st.
some material instruction and documents, file some documents. Right? So let it come on 10th of March 2020. Yes.
Item 11.
Item number 11 in the second sub-item and for the petitioner. Whereas in the first sub-item and for the opposite party number 2 and 3.
Yes.
I have to file a rejoinder in the second application lordships, and in the first one also I'm going to, of course, it's challenging the same the very same order is being assailed in both the cases.
where is Mr. Matthews
Matthews was there last time, I think.
He was there in person.
He said that he will hand over something to you.
Yes, a copy of the writ to your lordships.
You
He
have,
sent a
you have received that.
he sent a soft copy. I was on my legs. I was not able to open what he had.
So,
Your lordship may grant me some time. I'll file.
no, you want to file the rejoinder affidavit?
In the second case, your lordship.
Second.
I had some difficulties over that.
What about the first thing?
First, your lordship, it is both are your lordship challenging the self-same order.
You are not
I'm there,
required
your
to file any counter affidavit.
Not required, your lordship. It will be adapted.
What do you say, Mr. Mahapatra?
My counter in the second case is to adopted in the first case. After in the same order, both the cases have been filed.
Just file a memo to that effect, and since this should be in the second petition, WPC number 21599 of 2020. Ms. Pratyusha Naidu Land Council submits that she has received the counter affidavit filed by the opposite party number 1, and some time may be granted to file the rejoinder. Mr. Mahapatra, appearing for the opposite party number 1, submits that the counter affidavit which has been filed by him in this writ petition may be adopted as the counter affidavit in the connected writ petition, that is WPC number 30798 of 2024, and to that effect he wants to file a memo.
memoটা সেইটারে দিয়ে দেবে along with a copy of the
ସେ
counter
ସେ ଯୋଉ
affidavit.
first ରେ ଦେବେ ଆପଣ 30798 ରେ and he wants to file a memo in the connected swatch ହେଲା ଯଦି ସେ memo ଟି ଦେଲେ ତା ଦେହରେ ଲେଖିଦେବେ ଯେ ଏୟା memo file କଲେ ଇଏ ସେ memo is taken under
In the course of the day,
ଦେଲେ ତ ଲେଖା ହବ ହେଲା so Miss Naidu,
Lordships,
so when will take up this
Lordships,
matter?
anytime in March, Lordships.
the stay order is operated.
I
against
understand, Lordships, but the problem is I'm a
the
little bit.
entire amount since last 4 to 5 years that is being enjoyed by the client of
March 3, 3rd
Lordships.
March 2025. Acha, Mr. Matthews is not there, so we are writing non-obvious etc.
This on that day along with this.
30798 रे लिखिवे non-obvious for the petition.
List on 3rd March.
List on 3rd March with that. Memo ta Mr. Mahapatra देवे तक
just now.
कागज दे दियो तो please take the paper and write the memo and hand it to the very end. Plain paper order दे दें hand over. Yeah.
Item 12.
There of the petition to dispose of the representation by Annexure 7, page 21 regarding compensation of the cultivated land and also the service benefit to the petition.
Before whom you have filed the representation before the collector?
Before the collector.
Where is the documentary proof that you have filed the? You have not annexed anything.
Filed in 16/10/2024.
No, that is the date mentioned in that representation. But where is the document? So whether you have sent it by post?
By post.
By post. Where is that receipt? Because the most of the time the Land and Council for the state submits that they are annexing something, but in fact no such representation has been filed. So you have to give us that documentary proof that you have filed such a representation. Otherwise, where you will search for it if you have not filed? No documentary proof is now with us. Have you got any postal receipt with you? Well, if it is available, file with a memo. We are just to mention that it has been filed.
Tomorrow I will give the
Memo.
how is the
We are giving you 2 more days time. We are taking up this matter on Thursday. You file that postal receipt,
Yes,
right?
I will file it. But before filing this postal receipt, I have earlier approached this collector, the opposite party.
Mr.
According to
Counsel,
the
the very opening words you stated that you want the disposal of your representation. We are also agree to that, but provided that we are to be satisfied that such a representation
Yes,
has been filed,
I'll
right?
yes.
The Land and Council for the petitioner submits that representation dated 16/10/2024 has been filed with the opposite party number 2 on and the same may be directed to be disposed of. The representation has been annexed as Annexure 7. When we made a query to the Land Council for the petitioner as to where is the documentary proof that such a representation has been filed with the opposite party number 2 on 16/10/2024, the Land Council submits that it was sent by registered post and the postal receipt is available with him and he will file it and with a memo and the matter may be taken up on
Tomorrow.
On such and such date for them on
Tomorrow.
13th of February 2025. Can you file it? It is not available with you. So you have to contact your client to list this matter on 13th of February 2025.
Then 19. My land 19.
One more time.
19.
All right. List this matter on
19.
some 1 week time for them. put up this matter on 19th February 2025. Yes.
Item 13.
This matter was taken up on 21/1/2025. On that also,
My lord,
nobody appeared.
my lord.
What is the prayer in this writ petition?
I tried to understand, but could not.
You could not.
My lord.
So that is perhaps the petitioner counsel also thought that why have we filed this writ petition and the questions will be put to me. So let us not appear and so that the whatever order will be passed, let the court pass the order. Our chance to none appears for the petitioner when the matter was taken up on 21/1/2025. On that day also, nobody appeared for the petitioner on repeated calls. Put up this matter. So 17 तारीख को रखा ना 24 26
Here, my lord, the petitioner counsel himself is the writer, director, and actor. सब से निजे करछंती रिप्रेजेंटेशन भी से निजे दउछंती.
अच्छा वो सी जो मैटर की अरे ये तो गुड़ा मैटर में ये करथिलो. No, it has already been disposed of in number of writ petition. We said that
National Human Rights Commission को National Civil Tribe Commission
the representation पड़ेगा ना
representation and page my lord page 138
हाँ
ये निजे दस्तखत करछे.
I say we on 138%. We said that it is to be filed by the concerned petitioner. Why you have filed? So that is how we have disposed of all the writ petitions. अच्छा हाँ ठीक है. All right. Put up this matter on 24th of February 2025.
Item 14.
Presentation.
Opportunity दिया ही नहीं. Order the petitioner has never appeared.
Correction.
अच्छा सबूरे
put up correction. Order would have been correction of petition.
I think 4-5 we have disposed of 1 week back.
Yes, dispose of.
Item 15.
Order of the Honorable Court order dated 24/4/2025.
खाली मिस्टर नायक तादरे अन्य प्राइवेट पार्टी नाहंती तो प्रॉब्लम इज प्राइवेट पार्टी थिले विदाउट हियरिंग देम इफ यू सेट असाइड पुनी देन देल बी अ प्रॉब्लम जो मैडम पटनायक कर
ना से रेफरेंस रे गला
हां
रेफरेंस नोटिस आंकु हेइला पिटिशनर को नोटिस
ने रेफरेंस रे वाला माने 28 हेले somebody must have filed for an
18 the reference
हां हेले no other private parties only MCL.
Yes.
My lord,
No order to comply he नहीं बहु.
My lord, in this case, my lord, the order was passed on the very first day. Yes, my lord. The order was also not communicated to the contender, my lord. Only one postal receipt is there, that is at page 12. It is addressed to the special land action of the Lower Indravati project.
ହେଲା ଯେ ତ ଆପଣ ବୁଝି ଦଉନାହାନ୍ତି କେବେ କଣ କଲେଣି
Well, the contempt is not maintainable. This is the judge.
No, whatever it may be, an order has been passed to dispose of that. So you just
ascertain what is the stage of the status of
Petitioner
that.
ମଧ୍ୟ ଦେଇନାହାନ୍ତି ଗୋଟେ
ମାନେ
ମାନେ
order ଟା
କମ୍ୟୁନିକେଟ
ଦେଇନାହାନ୍ତି।
କରିଛନ୍ତି ବୋଲି
ଏଇ ଯୋଉ ଦଉଛନ୍ତି postal receipt ଟା
ଖାଲି ପୋଷ୍ଟାଲ ରିସିପ୍ଟ ଏଥିରେ ସେଇଟାକୁ ଦେଲେ କି ଗୋଟେ ଫରୱାର୍ଡିଂ କିଛି ନାହିଁ।
କି ଫରୱାର୍ଡିଂ ଲେଟର ଦେବୁ ପୋଷ୍ଟାଲରେ ଆମେ ପଠେଇଲୁ କନସର୍ନ ଅଥରିଟି କି କଣ କି ଫରୱାର୍ଡିଂ ଲେଟର ଦେବୁ
ଏଇ ଅର୍ଡରଟାକୁ ଏଇଆ
କଣ ହେଲା?
ଆଜ୍ଞା ମୁଁ ତ
Is this the way to behave in court? Then
ଆମେ କି ଫରୱାର୍ଡିଂ
key forwarding କଣ ପଚାରୁଛନ୍ତି? Key forwarding
The petitioner has already been.
ଯାହା କହିବାର ଅଛି କୋର୍ଟ କୁ କୁହନ୍ତୁ।
Yes, my lord.
Yes.
And I'm placing who
No, let him finish. Let him finish then. ଆପଣ କଣ ଦଉଛନ୍ତି ଦିଅନ୍ତୁ। ସବମିଟ
yes
ଗୋଟେ ଏଥିରୁ ଗୋଟେ ସେଥିରୁ ଗୋଟେ।
you have submitted to the authority on 11 5 2024.
My
So this contempt petition has been filed by the petitioner Chandra Maji for non-compliance of the order dated 24/4/2024 of this court passed in WPC number 9578 of 2024, wherein while disposing of the writ petition, this court directed the opposite party consider the petition filed by the petitioner under section 28A of the Land Acquisition Act and to pass appropriate order with law within a period of 3 months from the date of production of the certified copy of the order. And counsel for the petitioner submits that the order was communicated to the opposite party number 3, that is the Special Land Acquisition Officer, on 11/5/2024, and postal receipt was annexed the contempt petition in token of sending the order. The Land Council for the Safara Collector, Land Council for the state wants to obtain instruction in the matter.
And my first submission is the contempt is not maintainable because the order was passed on the first date and it is not communicated to the opposite party number 1 and 2.
Just obtain
Naik,
instruction.
the order which you have given, there it has been stated order passed in the same day. The contemptor was not a party to the writ petition. Is
Yes.
this the case here?
Here,
The order you have given of this
Yes,
court,
ma'am.
there the specific reason is that Jah Viruddhare contempt file he was not a party to the writ petition. So no contempt made out. Here you were a party,
Yes.
you were represented by a state council, and the order is for disposal.
The name of the Land Council for the state has also been reflected there. Is Naik is.
My submission only, well, opposite party number 1 and 2, they have not, the order was not communicated to them.
No, the
Who
state
are
was.
who is 1 and 2?
One is the Principal Secretary, Water Resource Department, and a Collector Nuapada.
And Principal Secretary, Water Resource Department is not supposed to dispose of the application under Section 28A. So you delete.
Special Land Acquisition Officer.
Only special, the order was communicated to the Special Land Acquisition.
Right.
He is the person to dispose of. So
Yes,
other
ma'am.
persons be deleted.
You are to take instruction from opposite party number 3.
Mallard.
Hello.
1 and 2 can delete Mallard.
And
There is-
another 28 as a separate proceeding in court.
সেটা বর্ষের
So
ভিতরে
procedure has to be followed.
Yes.
So for that you ask for an extension because when the court is passing an order, you are not disputing or saying that we want more time.
Right.
Since that order has been passed, you have to ask for
Present
extension.
କୌଣସି order pass ହୋଇଛି
Different issue ହେଲା ଚୁପଚାପ ଛିଡ଼ା ହେଇଯାଉଛି।
ଆଜି representation order ଟା dispose of ହେଲା आपण किछि कहलेनी से सबमिशन कले ऑर्डर यदि किछि कहिथांदे हमें रेकॉर्ड करथांतो whenever an order has been passed in your favor directing the authority to dispose of the representation, it is to be carried out from the date of production. That is how he said that he has already sent the order.
Only my submission is 1 and
All right,
2.
1 and their land council for the state submits. That sends the order has to be complied by the opposite party number 3. The special land official, there is no necessity of adding this opposite party number 1 and 2, this contempt petition. Land council for the petitioner makes a prayer, oral prayer, delete the names of opposite parties number 1 and 2. Accordingly, so and so stands deleted. Yes.
You want more time, you point out to the court or ask for extension.
Yes.
We are not passing that order on merit. You will go through that. So what is it?
I'll adjourn method.
Yes.
We are adjourning it. We are
Right.
granting you. You will take up on 24, just obtain instruction on that. Yes.
My lord, next item, my lord,
All are same.
16, 17, 18 are same.
अच्छा, same order. थोड़ा सब delete हबो, जेन पकड़ इतला करी instruction ପାଇଁ रखिबे और ता देरे से read petition number अलगा हो, order बोधे अलगा हो, थोड़ा देखि लेखिबे. Yes.
How last?
Item 19.
Previous order 24/1/2025 regarding my lord settlement of the issue, payment of compensation as per page 47, letter of the ADM to the executive engineer are
Just come to that order.
my lord
24/1/2025
Yes,
order. ସେଠୁ ପଢନ୍ତୁ.
ଆଜ୍ଞା ଏଇଠି ଅଛି
କାଇଁ ସେଠିକି ପଢିଲେ କଣ ଅସୁବିଧା ହଉଛି? ଆପଣ ପାଇଁ ଆମେ ସେଟା ରଖିଲୁ. ଆପଣ ସବୁ ତ ତା ଦେହରୁ ପକେଇବେ ଆଉ ଏଇଟା ରଖାଗଲା ପଢନ୍ତୁ.
Sorry, sir. The writ petition has been filed challenging the illegal and arbitrary action of the OP for forcibly occupying the scheduled land of the petitioners for construction of road and bridge without any compensation or settlement payable under right to fair compensation, transparency, land acquisition, rehabilitation, resettlement 2013, and with a prayer to pay the compensation and damage under section 26, 27, 28, 29, and 30 of the 2013 Act. During course of argument, Lord and Counsel for the petitioner referred to the letter dated 13/11/2023 issued by the Additional District Magistrate Revenue Policy OP number 3 to the Executive Engineer RW Division Policy OP number 5, wherein it is mentioned to take necessary action as per the order of the of the courts for distribution of compensation and to furnish action take a report within a week. The Lord and Counsel submit that in spite of such communication being made to the Executive Engineer, no step has been taken for which the petitioner has yet received the compensation amount. Let the Lord and Counsel but state of the instruction as to whether any order has been passed by the Executive Engineer RW Division 2, Balesur, pursuant to the communication made by letter dated 13/11/2023 of the ADM Revenue Balesur. So, my lord, it is given some instructions. It appears.
କୁଆଡେ ଯାଉଛନ୍ତି ସେଠି ବସି ଗପୁଛନ୍ତି. ଡାକୁନ ଏଠି ବସିବେ.
Office of the Executive Engineer.
Yes.
This Tahsildar has been instructed by her.
Wait.
With reference to the above cited subject, is to state that the letter has already been issued by this office, letter number so and so, dated 23/2/2024, to the Tahsildar Khoira to intimate the name of the present tenant of the land of Khatiyan number 91/13, plot number 321, and Khatiyan number 30, plot number 25, who will receive the compensation as the letter issued by this office, letter number so and so, dated 18/7/23, and letter number 3425, dated 18/7/23. The person reported earlier Rupa Sindhu Raula and Vasishta Raula by the Tahsildar Khoira was returned with remark of death address. The land acquisition officer Baleswar has also requested the Tahsildar Khoira to intimate the present owner of the above land. Why is return number so and so dated 18/7/24, but till date no report has been received from the Tahsildar Khoira. As soon as the Tahsildar Khoira reports the present owner land legal aid, this office will pay compensation to them. Plus, I'll take up this matter with the Tahsildar Khoira and report that.
Because it was the letter dated 18/7/24 and 6 ମାସ ହେଇଗଲାଣି।
Let me follow up
नहीं
with the
छह मास से मागिଛି ତାଙ୍କୁ
ହଁ ନାଇଁ ଇଏ ଦବା କଥା ନା, ଇଏ ତହସିଲଦାରକୁ ମାଗିଲା ଲେଟର ହଉଛି, ତାର ଲେଟର ହଉଛି 18/7/24, ମାନେ more than 6 months have already passed.
Tahsildar Khoira is not a party, so I will.
That is one thing, and another thing, legal air Tahsildar will not do. They will have to give.
They'll have to give. Let me
If nobody is there, Tahsildar, but since they are upload legal air certificate ଦେଇଛନ୍ତି
yesterday RI ଆସିଥିଲେ,
yesterday RI ହେଲେ ତାଙ୍କୁ ଧରେଇ ଦେଲେ ନା
ନାଇଁ ନାଇଁ ସେ କହିଲେ ଯେ ଯୋଉ genealogy ଟା ଦବା ପାଇଁ,
genealogy and the legal air certificate, otherwise they can't give. ତାଙ୍କ ନାଁରେ case ହେଇଯିବ ନହେଲେ। ଆଉ ଏମିତି ବି କରନ୍ତି, ସେ ଚାରିଟା legal ଅଛି, ଜଣେ ପଳେଇ ଆସିବ ମୁଁ ନେବି।
You have to sit here, ଏଇଠି ବସିବ, ଆଉ ସେ ତାଙ୍କର Land Council for the state has produced the written instruction received from Additional Chief Engineer, RW Division 2, Balasur, wherein it is stated as follows: quote for the Purada. Land Council for the state submits that some more time may be granted to him to obtain necessary instruction from Tahsildar Khoira. So we take up this matter a week after. Took up this matter in week commencing from, as this written instruction is taken on record for you. The matter will be listed in the week commencing from 24th February 2020.
Item 20.
You have received a copy, Mr. Mahan.
এটা document.
challenging the legality and the correctness of order dated manner 2024 Annexure 1 manner. Land is acquired 6 decimal manner. Annexure was on page manner.
You have filed a representation.
Annexure 5 page 13 manner.
We are asking you again the same question, that where is the documentary proof that you have submitted this representation to the collector?
Collector manner, my post.
ମାସେ ବି ହେଇନି ଦେଇଛନ୍ତି।
Acknowledgement is with you, madam. Postal acknowledgement.
ଦେଇଦେବେ ନା ଆପଣ ଆପଣଙ୍କ ପାଖରେ ରଖିଲେ କଣ
ଆପଣ ସେମିତି ଦେଖେଇଲା ମୁଁ କଣ?
Sorry, madam.
ଖାଇବେ notice.
File it with a memo. But don't give like this. What is this procedure you are adopting? File it with a memo.
Yes, madam.
Selecting them. କାହାକୁ ପଠେଇଛନ୍ତି ସେଟା କଲେକ୍ଟର
number 2 and 3 2 and 3
original ଟା କାଇଁ ଆମକୁ ଦଉଛନ୍ତି ଥରେ ଖୋଜିଲା ମିଳିବନି
ଆପଣ ସେଟା
ଗୋଟେ ପେପରରେ ମାନେ
ଜେରକ୍ସ କରିକି ରଖିଦେବେ, ତାଙ୍କୁ ଗୋଟେ ଦେଇଦେବେ କପି।
ଦେଖନ୍ତୁ ଏଇଟା ଦେଖନ୍ତୁ
କଲେକ୍ଟରଙ୍କୁ ଯୋଉଟା ଅଛି ସେଟା ଦିଅନ୍ତୁ। You want your representation to be disposed of by the collector, no?
Opposite bet number 2 and 3, 2 and 4 madam.
ଦି ଜଣ dispose of କରିବେ?
କଲେକ୍ଟର ତ କରିବା, ଏଇଟା ଆଡ୍ରେସ ଟୁ କଲେକ୍ଟର ଅଛି, ଆଉ ପୁଣି କଣ?
ଆଉ ଗୋଟେ ତଳେ ଅଛି।
ଆଉ କୋଉଠି ତଳେ ଅଛି? Annexure 5 is the page number 14. It is addressed to the collector.
Collector को ही ଦେଇଛନ୍ତି।
Page 4 para 6 madam.
Collector
that the petitioner stating such grievance has been referred to applicant 2 and 3.
ये तो register दिए देले जणको। तापस साहू कलेक्टर को ଦେଇଛନ୍ତି, ମନ୍ମଥ ସାହୁ ବି କଲେକ୍ଟର को ଦେଇଛନ୍ତି।
नेक्स्ट आइटम ଟା ଆଉ ଜଣେ।
ଆରେ ଓ ଏଇ ଆଇଟମ ଟା କୁହନ୍ତୁ।
ଲେଖନ୍ତୁ
ଏଇ ଆଇଟମ ତ ମନମତ ସାହୁ ସେ ତାଙ୍କ ରିସିଟ୍ ଅନୁସାରେ କଲେକ୍ଟର କୁ ଦେଇଛନ୍ତି ଖାଲି କଲେକ୍ଟରଙ୍କୁ ଦେଇଛନ୍ତି
ଡକ୍ୟୁମେଣ୍ଟ
ଏଟା ତାହେଲେ ଦିଟା କେସ ରେ ଦିଟା ତ ଅଲଗା କରିଦେବି
ତାକୁ ଜେରକ୍ସ
କୋଉଟାରେ କୋଉଟାରେ ଦେବେ ସେ ଦେବେ attach କରିକି
ମେମୋରେ ସେ ଦେବେ ସେଟା ଫାଇଲ କରି ଆଉ ଗୋଟେ ତାଙ୍କୁ ଗୋଟେ ଇଏ କପି ଦେଇଦେବେ
ଜେରକ୍ସ ଆଟାଚ କରିବେ
ଜେରକ୍ସଟାକୁ ଆଟାଚ କରି ଅରିଜିନାଲଟା କରିବେ
ସରକାରୀ ଓକିଲଙ୍କୁ ଗୋଟେ ଦେବେ ଏଇଠି ଆକ୍ସେପ୍ଟ କରିଦେଲା ବେଳକୁ ଆମକୁ ଭାବୁଛନ୍ତି ଆମେ ଫାଇଲିଂ ଦେବେ
এটা হচ্ছে annexure 5 টা dispose of হবো তাহলে লিখে দেবে the learning council for the petition of file the documentary proof regarding submission of the representation to the opposite party number 2 collector by है ना which is taken on record है ना बाकी disposal যেমন হবে
if there is no other legal impediment then I will notice
there is no legal
format ଅଛି କି ନା ଜାଣିନି
तो हाँ मेमो लिखिबे ओरिजिनल टा आपण रखिबे जेरॉक्स टा एठी हबो आउ
डेटा कोन अछि पोस्टल रिसीट रे डेटा कोन अछि से जो छोटिया रिसीट देले चेक करना जे
ठीक है
हां
13 एक रिप्रेजेंटेशन 17 एक देइछि
लिखिबे
हां अरे मेमो लिखिबे postal receipt dated 17 so and so is filed here with na yes next
total
21 22
2021
2021 all right dispose of
Item 22.
that is the considered matter yes covered
4 months दे दो से जो होला में 10 तारीख नहीं 4 months दे दो just they can see
जोड़ी जा करेक्शन हवा कथा कर दी
yes
ता कोन माने
make sure
regarding what
possession the land of more 30 years more my lord
settle the land nothing on merit
ये सब तो बस है
yes
all right
नहीं रे
वो चेंज हो yes next
Item 23.
yes
Total of the 28 application.
डेट देचन त within 3 months
Yes, sir.
हम पेटिशन रे
My lord.
आपण के सब अन्य मन को छी आपण डेट दोचन समान दोना काई आपण कर फर्स्ट ता देखि एप्लीकेशन को पैराग्राफ
Paragraph note is annexed to
3 ना 4 नहीं प्रोटेस्ट तापर डिस्पोज ऑफ हला 12 टू
Annex
2024
annexed to
183 ठीक अछि 183 के दिन भीतर दबा कथा
90 days.
ठीक
दियो सब तो कनेक्टेड मैटर से ही ऑर्डर तो
Same.
all within time
Yes, sir.
ठीक है इन मोड ऑफ सीट पे हमारी दिन डॉक्यूमेंट्स
Item 24.
It pleases to not say the limited grievance of the petitioner is that Lord. Lord, in lordship can kindly see running case 33. He has represented before the authority several times. But the last one, my lord, that is dated 6/11/24. Lord, because the land has been acquired since 2011 under the Coal Bearing Act, and he has not been given the compensation in lieu to the
which is
structure.
the last representation you said
My lord, that is under page 33, that is 6/11/24. 33, my lord. 33. Addressed to the opposite party number 3.
Now, for the land, you have received the compensation.
Land, I have received the compensation.
Have you stated that there is a structure standing while receiving it?
I have stated. And I have also stated that on 27/22, the civil and revenue staff have demarcated my land in that representation itself. And I only want the compensation with
For
regards
the
to the
structure,
and followed by the
so who is to dispose it of for your representation?
Chief General Manager, who is the opposite party number 3. 3 million. Yes.
The MCL says that in the claimed structures, there are no structures. Page 39, my lord, may kindly have it. Page 39, second subparagraph. This is the RTA reply given by the MCL.
Lord, that is my lord.
They have taken that stand.
That is under the RTI Act. I will avail the opportunity of appeal also, my lord. But the authority, my lord, they are signed. That is the, my lord. My lord, what I am submitting, my lord, that is a different footing, my lord, under the RTI Act. But he is not the rightful authority to dispose of my claim under the preferred structure.
I just went through I and for the MCL.
My lord,
MCL दबा देता तो मुझे 100 रुपये लगेगा.
The petitioner's father, my lord. Obliged.
Item 25.
May I please, Your Lordship? Under this condemned petition arise out of WPC number 23489 of 24, which was disposed of on order dated 17/2024, that that the petition is disposed of with direction to OP number 1 to dispose of the LA case in accordance with the within a period of 3 months. That is of order dated 17, and the production of the certified copy of this order. The certified copy is presented on 14/10/2024, annexure 2, page number 11, my lord, with the representations which are not yet considered. My lord, OP number 1, who is the OP number 1, my lord.
My lord. ନାଇଁ ନାଇଁ ସେ ଦେଇଛନ୍ତି ମୁଁ କହିପାରିବି।
Padhi, can you hear us?
Yes, my lord. Yes, my lord. I'm audible.
A contempt petition has been filed against railways. You are appearing for the railways.
Yes, yes, we are appealing for you.
There was a direction issued that to dispose of a LA case, and within 3 months from the date of production of the certified copy, and that 3 months period, according to the Land and Council for the petitioner, has already expired. So just take instruction. What is the
Well, yes, let's you give me a 10 days time. Will then take instruction. Let a copy. If my sister will serve a copy, then it will
served
help.
on you by tomorrow. It will be served on you, and
Yes, yes.
we are
I'll
giving
take
you
instruction
2
immediately.
weeks time to obtain instruction.
Obliged, man. Obliged.
Matter will listed आज ये वाला 2 सप्ताह दे देंगे 3rd March को करेंगे. Yes. We are just coming within 2 minutes.
Item 26.
This matters. There is no delay. Combination of delay petition has been filed.
Some defects have been shown. What are these 5B means?
Yes.
Few of these also. Okay. And this number 9 defect is, have you removed it? These are not legible copies are there. So many pages are there.
That is the Xerox copy is not there.
No, these are not legible. 49, 51 to 54. Just see yourself, Mr. Mahanti. Please see.
Yeah.
53 को पढ़े आसंतु 54 को आसंतु 54 to defect the KG office 54 ta
Submit your lordship can waive this because we have annexed the repetition cost. It is there in the record. Your lordship.
No, it's all right, but
Repetition that could not have given that, but just Xerox copies of that repetition, which is the record of this learned.
no.
That is the your lordship. Whereas for that reasons, notice was issued.
58 to 62, 68 to 80, 70. So many pages are not legible.
These are all not the repetition copies and the annexes. But you can find from the record of the honorable civil judge that repetition, and that starts from the that is my lord, from page 22 to 90.
Okay, we'll see that. But this matter is the delay has been shown to be 1061 days.
Delay is there. Delay is
So,
there. So reason being,
you have filed your delay condonation application.
my lord, you have filed that.
So what is the response of the or objection? Have you filed? Who are the opposite parties?
State, I think, will support us. But in this case, there is substitution petition as well. The response number 1 appeared through Mr. Mahapatra, and your lordship will find order dated 14/8/20.
14/8.
Yes, sir. The first order is 5/4/23, notice was issued. And your lordship will find 14/8/23.
14/8/23.
Madam. Mr. P.K. Mahapatra on counseling appeared for the respondent 1 has reported death of respondent 1. Let the matter.
Please, please.
Madam. It's 14/8/23.
Yes.
Mr. P.K. Mahapatra on counseling appeared for the respondent 1 has reported the death of respondent 1. Let the matter be listed 5th September 23. Mr. Mahapatra on counsel is requested to supply the details of the legal heirs of respondent 1 to Mr. Pranay Mahanti on counsel appealing for the appellant within 3 weeks, 3 working days. It appears that is a correction of the previous order. Then let's kindly see the order dated 5/4/23. Notice Mr. M. Pratap Kumar Mahapatra on counsel accept notice on behalf of respondent 1. Let extra copies of writ appeal be as well as the application be served on him within 3 working days. Then your lordship will find we have filed the substitution petition. That your lordship will find my lord, IN number 6157 of 23 at flag X for substitution of legal heirs by deceased respondent 1. And IN number so and so flag Y for condemnation of delay in filing of substitution, and IR number at so and so for setting as
But unless Mr. Mahapatra files Wakalatnama on behalf of the legal heirs, he cannot accept notice on the behalf.
that is right. That is. I
Because
filed so many petitions only.
respondent number 1 is not there. So
Not, so Lordship may issue notice to them.
No, if he's
Friend
willing to
appears
appear,
in all right. If my friends appear all right.
Have you obtained instruction on it? You are appearing for. So you are appearing for that respondent number 1, Dhiren Kumar Pradhan. So now he is dead. So the legal heirs are to be brought on record. So have you received any instruction from them?
Previously, I have informed on report that my client is no more and
Expired already. But
so
if you file the wakalatnama, if you take instruction, there is no need to again issue notice. That would concern the matter. So
will you take instructions if you will file Wakalatnama on their behalf?
we can take up next week. There is no problem. This process there would be delay.
Otherwise, the next 4 weeks or more time it will be taken. And if
2 weeks.
no, so 2 weeks you take instructions. Thereafter, you disappear.
Decon, IN number 6157 of 2023 is an application under Order 22 rule of the CPC, Regularization, so on so for substitution of the legal heir of the deceased respondent number 1.
Interception actually, combination of delay as well as
Dhiren Kumar Pradhan. Respondent number 1 was Dhiren Kumar Pradhan.
Yes.
All right. The Land Council for the respondent number 1 was appearing, submits that he may be given 2 weeks time to obtain instruction in the matter to appear for the legal heirs of the said respondent number 1. Is this matter weeks October and March 2025? Put of this matter along with one so say Aradhita jo aayi hai.
Have you received copies?
I know Aradhita I have indicate.
Have you received copies of the petition?
And
So, apart from appearing, you also have to take instructions if anybody has been left out.
Legal heirs जो 5 जनक ना ଦେଇଛନ୍ତି ତା ଛଡା ଆଉ କିଏ left out ଅଛନ୍ତି କି ତା ସେ ବିଷୟରେ ମଧ୍ୟ instruction ନେଇଯାଏ ହେଲା।
ଆଉ ଯଦି କାହା ପାଇଁ appear କରିବେ ଅନ୍ୟମାନଙ୍କୁ ବି ଆମେ notice issue କରିପାରିବା. So accordingly obtain instruction.
Our IN number so and so this is an application for condonation of delay. Our IN
कोटा कोटा कौन पे करेगी?
filed for so and so this is in file. कोटे order लिख देंगे. The entire file yes to obtain.
Copy टा दे दो. I would देती I would
just receive those 3 interim application copies. Right. And we are putting it on 3rd of March 2025. You have to obtain instruction.
All these matters are all.
एवढा अगर सबुथिरे अन्य अन्य आई अछि ना
से आई अछि सेक्टी किछि डिसीज ना
अच्छा बट condonation of delay अछि
condonation delay मतलब notice issue
ठीक अछि so this matter has to come along with the connected reproduction on 3rd of March
4th March
अच्छा ठीक अछि 4th March 2025 and केवल प्रथम टारे से जो अछि डेथ अछि और ये अछि एगुडा किछि ना yes next
Item 27.
Please, madam. My lord, here my prayer is for amendment of the petition. That is the only prayer portion to be amended. Because
just a minute. 28 one dated so so the higher number mentioned is not what to mention as chapter 79 higher number of 25. there was a correction problem. The registry has pointed out that in order number 28, the IN number has been inadvertently mentioned as IN number 797 of 2021 instead of IN number 797 of 2025. Stop. Let the IN number mentioned in the order number 28 be read as IN number 797 of 2025. Stop. Approach out of IA for amendment. Yes, what amendment
Sir,
you want?
Only the proposed amendment on the prayer portion.
Just-
My lord,
just-
only
just-
instead
just,
of
just a
sir,
minute.
sir.
Just a minute. With the other side.
I've filed an objection also here to the amendment. The petition was filed in 2021. Now through the amendment.
What amendment do you want?
Only amendment, my lord, to set aside the order passed by the Central Administrative Tribunal. That was the only amendment, proposed amendment. That will not change the nature and character of the petition.
You are
That is
challenging
formal in
also
nature.
that.
Sir,
So
Or you forgot to mention that in your prayer or what?
no. Only prayer we have to. They are making an objection that instead of making a prayer to set aside to pass the order passed by the Central Administration, only prayer was to give an appointment under compassionate grounds. That is formal in nature.
রিজেক্ট করলা এটাও তো
So unless you challenge it, how can you ask for that?
দেখুন IN number so and so, this is a petition or amendment of the prayer portion in the writ petition. The land counsel for the petitioner submits that in the first paragraph of the writ petition, it is mentioned that the writ petition has been filed challenging the dismissal order passed by the London Central Administrative Tribunal, but inadvertently the same should not be reflected in the prayer portion. Land counsel for the land counsel for the opposite party filed the objection to the petition. After hearing the land counsel for parties, going to the amendments taken in the interim application, we are inclined to accept the prayer made in the interim application. Accordingly, the prayer is allowed. The proposed amendment, the seal of amendment now shall form the part of the writ petition. Land counsel for the petitioner shall file the consolidated writ petition incorporating the proposed amendment. The copy to be furnished to the land counsel for the opposite party.
With my lordship's permission, the consolidated petition is here. Okay.
The amendment should have which add.
No, nothing. Only amendment. I have given the copy also, my lord.
Let him verify. देखी दियो खाली अन्य कौन खाली we are taking up this matter day after tomorrow. You just go through it.
Please.
What schedule ଥିଲା ଆଇଆର ନା କାଇଁ?
Proposed amendment will.
ଅଛି ହଁ ଅଛି।
But there is no addition to the paragraph. There is no additional pleading. Only the
No,
prayer.
you just
Only by the proposed amendment, only for prayer.
I've gone through.
All right. You will just
Not in proper order, but what to do?
copy of the so serve on the land council for this one. Matter be taken up.
First portion.
Day after tomorrow, they can. Next.
Obviously.
On the religion.
Just a minute, what was your
God.
What was your prayer in the writ petition? Mr. Ponda?
He's gone.
Sorry,
Sorry, my lord.
Petitioner number 2 under company under public sector rules and any other may be passed. Eventually and to please quash order the quash set aside the order dated.
ଆପଣଙ୍କର ଯୋଉ ସିଡ୍ୟୁଲ ଅଫ ଆମେଣ୍ଡମେଣ୍ଟ ରେ ଯାହା ରହିବା କଥା
ସାର୍
ଆପଣ ସେତିକି ପୁରେଇବେ ନା ମୁଁ ସେଇଥିପାଇଁ କହୁଥିଲି ଆପଣ ନା ଅଧିକା ପୁରେଇ ଦେବେ ତାକୁ
ନା only schedule of prayer only prayer portion sir. ଆଜ୍ଞା
ଆପଣ ସେ ଯୋଉ schedule ରେ ଦିଆ ହୁଏ ସେଟା inverted comma ରେ ଦିଆ ହୁଏ so that ସେତିକି ହିଁ ପଶିବ।
ଆଜ୍ଞା
ଆପଣ ଗୋଟେ ଜେନେରାଲ କରି ଦେଇଛନ୍ତି ଏବେ ଆମେ କାଢିବାକୁ ପଡିବ କୋଉଟା ଆପଣ ଦେବେ ଆପଣ schedule ଦେଖୁନାହାନ୍ତି କଣ ଲେଖିଛନ୍ତି ଏଇଠି କଣ ଦେଇଛନ୍ତି। ଦେଖନ୍ତୁ schedule ଟା
ସିଡ୍ୟୁଲ ଅଫ ଆମେଣ୍ଡମେଣ୍ଟ ରେ ଯେତିକି ଆପଣଙ୍କର ଲେଖିବା କଥା
ସାର୍
ସେତିକି ଇନକର୍ପୋରେଟ ହବ ନା ଆଉ ତା ଛଡା ଆଉ ମନ
ନା
ଇଚ୍ଛା?
ସେତିକି this much only.
propose amendment ରେ
Order passed on 6/10/2021 in OA number 346 of 17 by the Central Administrative Tribunal, Kotak Bench, Contempt, by the Annex 10 may kindly be quashed.
ତାପରେ କୋଉଠି kindly be quashed set aside ତାପରେ
The proposed amendment in the prayer of the writ petition may kindly be allowed under Order 7, Rule 17.
that is also a proposed amendment.
The same nature is same, sir. Same. There is nothing new.
No, it is not in order, only the first portion permitted to.
That's not.
Item 28.
Thank you. We'll also have all this matter next week because I have filed documents, wakalatnama along with the corrected petition. I filed an application for substitution of the petition number
You
1.
have filed or you will file?
My lord, I have already filed. Already filed the number. Today it is only the number. Copy of
1628.
It was 1628, but today I have also filed and further I am 2475. Since the earlier the IA was not in the
So you don't want to press this IA?
Yes, Your Lordship. The fresh IA I'll place, Your Lordship.
This has already been filed today.
Yes, yes.
All right. IN number 1628 of 2025. There is an application filed under Order 1 Rule 10 of CPC for substituting the legal heirs of petitioner number 1, Ms. Samoni Behra. Plan counsel for the petitioner submits that he does not want to press this interim application and a press interim application has been filed today, which has been numbered as IN number 275 of 2025. Stop. Let the IN number 475 of 2025 be placed on record. It of the matter will be listed next week. It not press kar delo.
Item 29.
Time pass over.
Amendment
Item 29 pass over.
29 pass over.
Okay.
Yes.
Item 30. I have included the project director, National Highway Authority of India, adjustment of post.
Right. 29 pass over. So National Highway Authority, you have now filed an application to implead as party. So any objection, it is to be formally mentioned. All right. You have already entered appearance. Ajay, you are to file that.
I local because my Lord friend has given today. I am will take in second.
All right. This IN number so and so. There is an application for including the project director, National Highway Authority of India, so and so as party. Copy of the interim application has been served on the Nafandi Junction also, who submits that he has Project Director, National Highway Authority of India. Out of the project implementation unit. On it, the address of the Purada.
NHAI implementation. Implementation to delete हो.
Implementation. खाली NHAI नहीं रहे. सही नहीं रहे.
नहीं डिस्ट्रिक्ट गंजाम जे रहबो NHAI implementation कटि जो.
अच्छा.
ଆଉ पार्टी पर हो एटा कोड बाचो.
हाँ भाई गंजाम. सही नहीं. Project Director तो डिस्ट्रिक्ट गंजाम नहीं रहे. Submits that he has instruction to so and so, and he'll file the appearance. Appearance में ना वकालत ना will file, and he has no objections when the IA prayer is allowed to also be added as opposite party number 6 in the
6 नहीं से तो 4 को जोड़ दीजिए. से तो 4 को जोड़ दीजिए. Consolidated इच्छा अनुसार
consolidated copy I have been filed.
consolidated तांको OP 4 दीजिए. तांको इच्छा अनुसार
ଆପଣଙ୍କର repetition ରେ ଆଗରୁ ଥିଲା 5 ଜଣ
Minor there as pro forma so that in opposite party.
ଆପଣ prayer ରେ ସେଟା ଲେଖିକି କହିବେନି ଯେ ଅନ୍ୟ ମାନଙ୍କୁ ରି ନମ୍ବର ହଉ.
opposite party number 4 ହେଲେ ଏମାନଙ୍କର ନମ୍ବର ଗୁଡା ଚେଞ୍ଜ ହେଇଯିବ ନା.
ସେଟା prayer ରେ କରିବାକୁ ପଡିବ.
Consolidated copy of the cost entry.
ସେଠି କଣ consolidated ଦେଇଛନ୍ତି.
ଦେଇଛନ୍ତି ତଳେ ଲାଗିଛି ଆଇବ ତଳେ.
ଆଚ୍ଛା.
prayer ନାହିଁ ଯେ ରି ନମ୍ବର କର କି ଆକୁ କୋ ଅପି କର ଏଟା ସବୁ ଆମେ ରିପୋର୍ଟ କରିବୁ which is not
ଏଟା କରିଦେବେ ତାକୁ. The consolidated transfer has been filed. It is accepted. କେବେ ରଖିବା କୁହନ୍ତୁ.
prayer कर दियंतु included opposite party number 4 order अनुसार consolidated है ना ताकि इच्छा अनुसार
opposite party number 4 and
the proforma opposite party is renumbered
opposite parties number 4 and 5 be renumbered as proforma opposite parties number 5 and 6. So after instruction in as well. So might be taken up on 24.
Next week.
Yes, next.
पासवर्ड थिला ना दीटा डाकी दो लास्ट ना ना फिर तो
ଆଗ ଅର୍ଡର ଅଛି ଲେଖା
यूसी मार्किंग करो ना का आनिए ଆଉ
ये फाइल वकाला ना मा
ନା ଭୋକାଲ ଲେଖା ହେଇଛି ମୋ ନାଁଟା ଫର୍ଷ୍ଟ ଡେଟ୍.
it's all right.
ପ୍ରିଭିୟସ୍ ଅର୍ଡର ନୋଟିସ୍ ଅଲରେଡି ରେକର୍ଡ.
24.
Start copy and
Yes, next.
फर्स्ट टाइटल रे नाटा लिख देबा सो
Okay.
Password. That will mean get number.
Passover item number 2.
Item number 2, Mr. Satpathy. आज ये बेटा का fifth order है ला. Order number 1 में detail mention है. Last.
नहीं माने अनअपियर्स है जे ना adjournment नहीं थी.
नहीं adjournment है जी. About the
हां तार लिख दे.
non-appears for the petitioner. Place this matter in the commencing from 3rd of March 2025. Number date together.
Item 6.
तो नुआ डाउ.
ठीक है हाँ এটা नुआ मैटर जी.
ना ना ऑर्डर भर्ती है जी से ऑफिस नोट इंडिकेट करने. अनफॉर्चुनेट.
Ready becomes 1,
2, 3, 4 चारटा ऑर्डर हलानी एटा फ्रेश भलिया लागुजी लिखिया कथा अर्जन लिखा है सॉरी अर्जन लिखा है
टाइम नहीं.
टाइम नहीं चलना ना अपियर्स
नहीं चलता है.
टाइम नहीं.
टाइम तो आउट ना
non-appears for the petitioner. तो petitioners कर देगा ना. So this matter on 3rd March 2025. Yes.
Item 29.
Mr. Jana, Jana,
We are for the opposite party.
Mr. Buchayat and Mr. Padi is there.
Yes.
So, there is an amendment application filed. You have received the copy of that.
Yes, I received, yes, 788 of 2022-25.
The opposite party number 6 could not actually put but they are not appearing. So,
Next week.
none appears for the petitioner. And counsel Mr. Padi, Mr. Buchayat present of this matter next week. Yes.
We
Item
have
31.
submitted that he was implemented in CAT as a party, but here they are not implemented. That's why it was filed.
Next week, Ashish, it
Next
is
week.
not there.
Yes.
Next.
Yes.
Mr. Kanungo,
Yes, ma'am.
item 31.
In item number 30,
Ma-
Your Lordship has directed the State Council to produce the record of WL in this case number 20 February 2013. Can I press for some more time?
My lords, this is the third time the state is taking
One last
time.
chance.
My lords, it's going on and on. Every time they say it's a last chance. My lords, let me just explain the
First date on 26/11/2024, time was granted to you. Next date is 4/12, then 17/12, then 21/2025.
They constituted a team to trace out the record. Lordship, one more chance, I'll come back.
My lords, your lordship is aware of this case. For madam's, my lords, appreciation of the case. My lords, my vendor's vendor, after who was an SC person.
I may be aware of the case, but if they are asking for time to produce
Asking
the
for
record,
time,
what
my
can
lords,
I do?
this will go on. They will never be
This is
able to
one
trace
last
out that
chance.
record. And on 2 occasions, your lordships have warned the state that this is the last chance.
So, madam,
I seek
what do you
only
want?
for 10 days. If
10 days, we'll write in the order. You take that order and show
Yes,
to
sir.
whichever authorities you
Yes,
want.
All right, land council for the state, 16 days time to trace out.
2 weeks is it?
Acha, 2 weeks, 2 weeks time to trace out and produce the records of WL miscase number 23 of 2013.
Time has been granted earlier.
Mr. Milan Tangal and senior advocate vehemently opposed to the prayer for adjournment and stated that the matter has been adjourned for such purpose on 4 occasions. Be that as it may, list this matter on 24th of February 2025. We are getting 2 weeks time.
much.
It is made clear that no further adjournment shall be granted on that
For production.
for production of the WL miscase number so and so. Yes, next.
Oblige.
Item 32.
Copy of this order.
Copy of the order be handed over to.
What
the
copy?
land
This
council.
matter has been targeted by the Supreme Court itself. The disposal.
Yes.
Going on taking time.
Item number 32, Mr.
My lord,
Bangari.
item 32, last occasion I took time to file counter after transferring the bill.
Direct for personal appearance and the officer, will that help?
Not this time. I'll comply with that within day.
Yes, sir. Yes, Mr. Pari.
My lord, the last occasion I took time after getting transfer from the Mr. Swine. But I examined the records that this Bombay High Court passed an order against which the Ministry of Law is examined to file SLP against that order. That is impeding the filing of counter. Let me give 4 weeks time because it is a case where the association filed 2 cases. One is inspector group, another is officials group. They want the scale of pay. They think the all India issue, my lord. That's why the longer time is better, my lord. 4 weeks time may be given.
Anywhere
I think my.
You say that it has been challenged in Bombay High Court also.
It's Bombay High Court passed an order against which now expenditure is examining the same. But what instruction I have received, it is under the examination Ministry of Law. They are preparing. That order and let him file whatever affidavit he has to file. Yes, I will file the detailed affidavit, my lord. Let's give 4 weeks time.
For that, time has already been granted, but
Yes, my lord has granted time. Last occasion I took time, my lord. I am considering that.
last time 24/1/25.
But they want more time to file a detailed counter because
All over India, there are many cases are there.
And Deputy Solicitor General, India, along with Mr. Buchai, Land Council, Central Government Council.
When another two council is appearing, Asotus and another is Sir. Sir, already sleep for
it's 4 weeks time.
4 weeks time.
4 weeks time. File. Reply, it is mentioned as reply to the additional affidavit filed by.
Yes, that reply of office, last occasion I prayed for this because I didn't have a copy. I'll collect from my land senior.
You are to file a counter affidavit or what?
Yes, we'll file the detailed counter affidavit.
Detailed counter affidavit to the writ petition. Put up this matter. Jari Sapta Ajihalla Prosdari Sapta Shargo 17th of March 2025.
Obligement.
El Pangari and Council is present.
Both case, my lord, both the case.
Both the cases, this matter.
Setre connecting out cases.
WPC number 8821.
Connecting case.
From March 2025. Yes.
Obligement.
Item 33.
Item 33, fruitful trades are there. That is, the land was acquired in the year 2007 with a mule that the land books will get the appointment. And my lord, the other point is that there are 714 acres of 20.8 acres.
No, just Mr. Let us see that this is for final disposal.
Yes, my lord.
So the parties have the pleadings are complete.
Yes, my lord.
Counter affidavits, agenda, everything is complete. Okay.
Kindly see the last order.
Last order.
On 7/8/2024. 7/8/2024.
No, thereafter another order has been passed. 12/8/24. The order is last one.
Directed the State Council to produce the original report.
No, there is no such thing. It is stated that you are to file the counter affidavit.
Out of the file.
So, Land Council for the OP 5 and 6 submitted that during course of the day will hand over the counter affidavit. So these are which record you want, madam?
The record of the settlement case number 88 of 1992 and miss case number 20.
Which case? Item 33?
33. 34. My
No, 33.
The whole case.
Achha. Who is appearing in this case, item number 33 for the opposite parties?
Well, it's 5 and 6. I'm making a mention on behalf of Mr. VP Tripathi, learned senior advocate. Hello, date chart is to be filed. I pray Lordship may call it next week.
There are 6 opposite parties.
Yes.
I think the state will appear for 1, 2, 3.
State has already filed the counter.
4. You are appearing for 5 and 6. Yeah.
They have also filed the counter.
The
I also filed the rejoinder.
party who is supposed to utilize the land.
713 acres of land were acquired since 2007. Till date, they have utilized only 150 acres of land.
You want employment for the
land losers.
Number 2, 6, who are the land losers.
Yes, ma'am. Usually, because our land has acquired, but they have not utilized it. And till that state is taking the rent from us. That rent dispute we have also filed. And they have admitted that they have not utilized that land till date.
No, have they acquired your land?
They have acquired the land. They have paid the compensation, but they have not utilized the land. As for the decision, if they will not utilize the land, they are bound to refund the land. It is the duty of the collector and also RDC to take the appropriate step for that.
But your prayer is something different. That prayer is to give employment. It's not to
one employment and to either refund
either employment or refund.
Refund the land. Yes, madam. I'm ready to refer the entire amount along with the interest to the.
So in your counter affidavit, what is your stand?
My lord, if as far as the appointment is concerned, if I may be allowed to draw lordship's kind attention to pages 182 to 187, my lords. In that, my lords, the petitioners, my lords, they have been recruited by us through an outsourcing agency, my lords, and the offer letters and appointment orders are annexed, my lords, for lordship's kind perusal. And my lords, the
Opposite party number 2 or 2.
But in that aspect, I have filed the rejoinder and taking a fee. They have utilized. They have utilized a daily wager. We are not getting the benefit of the regular employee.
So what do you say? This type of engagement they do not want as for the policy decision or the as for the.
Have you gone through? Don't read here and tell us, because one question we'll ask, again you'll go through.
my lords, I pray if my lords may kindly take it up next week, my lords. Entire date chart will be
No,
finalized.
date chart and all points
Yes,
should
yes,
be
yes.
ready also.
Mr. Tripathi, I'll give this matter.
Whoever comes has to be prepared,
Yes.
because he has 5 prayers,
Yes,
different types of prayers, 5.
my lords.
All right, Mr. Kishore Kumar Janam, Land Council, appealing for the petitioner, Swansea is appealing for.
Your name, please,
Give your name
Pankaj Das.
on behalf. Sir.
on behalf of Mr. B.P. Tripathi,
P 5 and 6.
opposite party number 5 and 6. Submits that the matter may be taken up next week in order to prepare a detailed date chart. Please, this matter will be commencing 17 February 2025. Yes, great.
By serving a copy to me also.
Give a copy to the Land Council for the petition. Yes.
Item 34.
Mr. Rao.
Yes.
Acting Chief Justice minus 5. Yes, Mr. Rao.
On the last occasion, Worship are directed to produce the original reports. Worship on the last occasion directed the State Council to produce the settlement records in original.
Yes.
May. Yeah, here acting. Here, order to S.K.Sahoo.
Yes, Mr. Rao, have to manage well the challenge in the restriction is Annex 6. The art pass of the learned tribunal, administrative tribunal.
An order, detailed order has been passed by us in earlier.
Yes, your lordships were considering this matter, and while considering the matter is the petitioner, while working as a land reforms commissioner, Qatar, has disposed of some matters in his judicial capacity. And after there was a departmental proceeding against him, saying that these orders were passed to the detriment of the state. Therefore, your lordships have due to verify what are those orders. Therefore, your lordships have passed an order calling for those records.
Right. No, let us see that order which you are challenging here.
Yes, order is Annex 6.
Annex 3.
6.
6.
At page 106.
First challenge the matter of the central administrative tribunal.
Yes, yes.
And what you challenge actually before this?
When order was passed,
You are into with the charges had
That is on 27/6/2002. And the charge is Jagar Singh, while working as Land Reforms Commissioner, Board of Revenue, Orissa, Cuttack, during 1998-99, passed illegal and irregular orders in favor of private parties in settlement revision petition number so and so, causing huge loss to the government. Thus, he has committed grave misconduct and gross irregularity while failure to maintain absolute integrity in the above matter. And there were okay. Then you filed your written statement.
I filed a reply
And
stating that as an act,
then the inquiry officer was appointed.
yes,
And the finding is
In my
just read
file.
that finding. That is in page number 2 of the order of the administrative tribunal. Page 2, that inverted comma vitaraj.
Yes.
Please come to the order of the Central Administrative Tribunal.
Yes, thank you.
Paragraph 2 of that order.
Yes, in response to this, the applicant submitted his written statement of defense dated 30/12/2002, denying the allegations leveled against him. Resultantly, an inquiry into the matter was conducted and the IO submitted his report on 19/5/2006, which was communicated to the applicant by the Annex 3 dated 14/11/2006, requiring him to submit his representation thereon. In the report, the findings of the IO are as under. I am of the opinion that there is nothing on record to show that the DO has made any backdated orders. The prosecution witnesses has also not stood by his written statement, but there is a strong impression that his orders have been biased in favor of the private parties against the government, standing counsel representing the government, and therefore the public interest. The Apex Court judgment of 1999, cited by the DO, while holding that a wrong interpretation of law cannot be a ground of misconduct, has also stated that, of course, it is a different matter altogether if it is a deliberate and actuated by malafide. So, while biased order against government interest seems to be apparent and to that extent irregular, I am not in a position to assert that this speaks of lack of integrity or the DO himself is responsible for causing loss to the government. The DO has acted as a court, and any procedural irregularity ought to have been challenged before the next higher authority. I therefore cannot recommend any punishment to the delinquent officer.
Okay, this is in your favor.
In my favor.
Then what happened?
Then the disciplinary authority, while considering this report, did not agree with the findings of the inquiry officer and asked me to submit a show cause as to why punishment shall not be given.
Okay.
Then I have given my submissions, and in spite of that, then the disciplinary authority has passed an order saying that.
What is that order? Has it been quoted there? What punishment has been imposed?
Yes.
That is paragraph 4 or what?
Paragraph 4. Okay. Now, therefore, keeping in view all the facts and circumstances of the case, the central government has decided that a penalty of withholding 5% of the monthly pension for a period of 10 years, otherwise admissible, is imposed on so and so with immediate effect in agreement with the advice of the UPSC, and also that his gratuity be released if not otherwise required, it ordered accordingly.
Okay, that you challenge, and what is the view of the Central Administrative Tribunal?
Central Administrative Tribunal, the last will kindly turn to
what is the operative part of that order?
Okay. At page, from page paragraph 9, at page 113, the reasoning has been.
Yes. Paragraph 9.
In paragraph 12, they have finally said that it's a violation. Let me place from paragraph 9. It has been submitted that central government, after taking into consideration all the facts and circumstances of the case, passed the final order dated 13/9/2011, which was communicated to the applicant by letter dated so and so to impose punishment on the applicant as already quoted above. It is the contention of respondent number 3 that there has been no procedural violation in the conduct of disciplinary proceedings against the applicant, and therefore the OA as late being devoid of merit is liable to be dismissed. Applicant has filed a rejoinder to the counter. In the rejoinder, it has been submitted that initially the IO recommended that the applicant being not guilty, no punishment could be awarded, but the disciplinary authority imposed punishment, which is the subject matter of challenge in the OA. According to the applicant, the contentions raised in the counter are not tenable since the points urged therein are not borne on record and based on incorrect approach. Applicant has submitted that disciplinary authority misread the judgments of Honorable Supreme Court in as much as law laid down is that in course of functioning, interpreting a judgment wrongly cannot be a ground for action or misconduct. The only exception pointed out by the Honorable Apex Court is that it is only when the act of delinquent is deliberate and malified, action can be taken against employees. Whereas in the case, neither there is any material to point out malifieds, nor the authorities have been able to point out so. The disciplinary authority picked a reason here or there only to victimize the applicant. The reasons pointed out by the disciplinary authority are based on errors of record, misreading of the views of in judicial pronouncements, and based on wrong facts. The applicant has also pointed out that in view of the decision of Honorable Supreme Court in the J.B. Nagarkar, the decision taken by the applicant in the capacity of Land Reforms Commissioner, even if wrong, cannot be said to be construed as misconduct. We have heard land counsel for both the parties and perused the records. We have also gone through the written notes of submission filed by the applicant along with the citation. In this connection, it is to be noted that Honorable Supreme Court in Union of India versus S.K.Sahoo 1993 2 SPC has laid down 6 instances when action could be initiated against the officer exercising judicial or quasi-judicial procedures. The observations of the Honorable Supreme Court in this regard are extracted here.
Just please skip over. Just come to paragraph 12.
In the above backdrop, this tribunal is to consider whether the action taken by the applicant on account of which he has been proceeded against and ultimately punishment imposed comes within the scope and meaning of law laid down by the Honorable Supreme Court as quoted above. In this respect, we have perused the disagreement notice as quoted under paragraph 1 of this order. Amongst other things, it has been mentioned therein that it is a settled principle of law that the Commissioner, when he exercises the powers of Board of Revenue and passes orders, those orders are treated as orders of the Board of Revenue and are not revisable on the principle that Board cannot revise its own order. Besides, without invoking the provisions of Section 5 of Indian Limitation Act and without receipt of any application from the parties for condonation of delay, the MOS has allowed the revision, which is vulnerable and cannot be sustained. This action of the applicant by far is violation of law laid down by the Honorable Supreme Court as discussed in paragraph 11 above. In view of this, it cannot be said that the applicant had not committed any misconduct and therefore the punishment as imposed on him in our considered view does not warrant interference. In the factual circumstances of this case, we are not inclined to accept the argument advanced by the applicant, and even if the decisions taken by him in the capacity of Land Reforms Commissioner are wrong, the same cannot be considered as misconduct.
So what orders were passed which he has revised, and that too the orders say that he has no power to revise that order, and number 2 is that the provision under Section 5 of the Limitation Act was not taken into account.
Did he merely correct the orders or change the order totally?
No, there is no. Let us see the first order and what he changed.
Yes.
The first order was passed by you.
Yes. That you will also get it at page 45. SRP number 88/92. Yes, that your lawsuits called for the records there. Yes, that will. Yes, the SRP case number 88/92. This 88 is initiated on a petition filed by one particular person. SRP case number 88/92 was a case initiated on the petition of one Abdul Aziz.
The first order is 25/11/1993. It was modified on 1993.
Yes.
And that was modified on 9th March 1999. Thank you. And the second order is 9th March 1999. Yes.
Okay, Substitution. Case number
88/90.
yes, 93/99. Hmm. The civilian demanded to prosecutor Contempt to verify the details of the trade transaction, find out the entitlement of the petitioner and to objective the inquiry about the position and to correct our under section 30 proceedings transfer the direction 19 on the verification. This order was revised. Revised on miscellaneous application has been filed by petitioner. Yes. A modification of that particular order. Correct. And the order has been passed. The operative part of the second order, that is the modified order. That the division is therefore allowed record all numbers one two in the name of the particular party. Direction was given to party. Whether that authority was earlier passed the order finding the matter particular order.
into all these things and then start the model. Can any model like this and how we care available and if this sort of model is part, whether the amount and
This original art. No, I was not that. Somebody else. Previous officer. This is only a review petition filed before me. No, no, right? No, there are 5 cases.
There are 5 cases.
But that earlier order, there was a mistake by stating that that was under the state. So therefore, this was corrected. This purchased land. This was land was actually purchased land. That was a mistake in the original order. Treating it to be the state's land. Therefore, it is reviewed because after that unregistered sale deed was produced, but he has taken a decision. But can it be said that it's a misconduct?
In all other cases, the modus operandi is same. One miscase has been filed and he has recalled his own order and passed the threshold.
Yes, ma'am. No, that no, no. And what I am submitting is, if the second order is wrong, the state could challenge it. They have not challenged it all. Yes, yes. But if the order on the face of it is error, can it not be corrected, my lord? Suppose the original order on the face of the order, if that is not correct, or based on errors of record, that is the point, my lord. Here you will also find the previous order. Let me place it. Yes. Completely different order. Different order means suppose the earlier order. Yes, if suppose the earlier order is based on an error of record or completely contrary to law, when it is pointed out by way of a revision, by review petition or by modification petition, then that can be entertained before the. Yes, I have filed my reply. At page. Yes, day after tomorrow.
45.
There, your lordship was issued a notice, it's a contempt matter. And last occasion, your lordship wanted to find out whether we have filed SLP. Because our stand before your lordship was there was a SLP that is filed and pending. Well, today I have informed my other side that yes, and I have given the copy of SLP. SLP, that is a diary number. So what I making a submission, if your lordship grant me 6 weeks time, and therefore this matter for 6 weeks.
My lord, after filing the contempt petition, SLP has been filed by the I have no objection. A short period may be granted. Because in the meantime, 10 months has already been. Now.
45.
Only diary number has been made, no SLP. Again, I think it's more of this. I like
annex SLP. SLP.
81 of 2025.
Page 7 re ଅଛି indictment. Page 7.
You know, 17th March.
Pardon me, Lord, item 40. 40. Readings are complete. But may I please that Lordship take it up, not unconvinced my Lord. 44. There is no entry order because first week of first week of April, my Lord, because it is challenging cat judgment, my Lord. First week of April. First week of April for any.
DK Sahoo.
Before the criminal appeal, challenging the
Weekly list item number 1.
My lord, appellant before this criminal appeal, challenging the judgment dated 8 থেকে 2025 passed by the law and second additional session in ST number 977 in अभी 2008 है ST number 15/677 अभी 2008 conviction manner under section.
What about the other accused persons?
I am only I am
No,
one.
I know that you are one, but as it appears that how many persons have been found guilty?
Minus 7%.
7%. Whether they have preferred any separate appeals or not, you have
Knowledge.
because the LCM might have been there, so that is why I admit call for the trial court record. 20 applications for bail and stay relation of fine will be considered of this case. Yes, the position copy to be supplied to the young counsel. Yes, pleasure.
Item 2.
Lordship, appellant 1/2/2025 से सरेंडर करें.
Right. First count. Peruse the report dated 1/2025 of the London trial court, which indicates that the appellant after appealing the interim date of surrender for the trial court on 1/2025. Yes.
Item 3.
Surrender certificate now. File also. We are appearing for the
Mr. Dwivedi, Sujatan Dwivedi.
Available.
no, that's item number 3. None appears for the appellant. Later, instruction be obtained from the London trial court as to whether after availing the interim date period as per the order dated 29/10/2024, passed in this case number 1720/7 the appellant surrender or not. Appellant's now the
I have already surrendered and filed the surrender copy.
fine.
Filed.
By
That is Mr. Dwivedi and counsel for the appellant submits that after availing the interim period, he has instructed that after availing the interim period, the appellant shall surrender in the trial court, and he may be given some time to produce the surrender certificate. Because this matter will be commencing from 24th February 2026.
Have you obtained the instruction regarding conduct? There is something noting.
Also, the land counsel for the state shall in the meantime obtain the report regarding the conduct of the petitioners appellants while an interim bail. Yes.
Item 4.
Last is when you lost it, but also the custody side.
Yes, my lord. I have
କିଏ ନାହାନ୍ତି ପାସୱାର୍ଡ
ପେପର ବୁକ୍ ନବାର ଥିଲା ଆଉ ନାହାନ୍ତି ଆଉ।
ଲାଷ୍ଟ ପେପର ବୁକ୍ ପାଇଁ
ଆସିଲେ ଜଣା ପଡିବ
You have received the paper book.
ପାସୱାର୍ଡ କଥା ନେକ୍ସଟ
Item 6. My lord, an application paid for bail. IA number 41 2024. My lord, the last occasion, what was the custody certificate?
Yes, I will receive the purpose.
To check.
how many years you are in custody
2650.
କଣ
2650.
Huh? 100?
More than 8 years.
2600?
26. 26 ପାଞ୍ଚ ଦିନ।
are you aware or not
Sorry. Minor commission for life life imprisonment under section 302 education number 8 2017 judgment is 11 occurrence date 24/11/2016
what is the prosecution case come to paragraph number 2 of the judgment
my lord. The accused namely Sri Mahadev Kishan.
Paragraph number 2 of the judgment.
2. Persecution case in brief is that the occurrence was taken place in the night of 24/11/2016 and about 5 p.m. in front of the house of the accused and deceased at village and under Badmal PS. The informant is Ashok Kishan. PW1 Ashok Kishan. Who is the brother, the deceased and the accused? Alice alleged in this affair that there was a quarrel taken place between the brothers in front of the house, and the accused Madhav Kishan got angry at brought one bamboo stick from the house and assaulted on the head of the deceased. The said accused left the spot thinking that the deceased died at the spot. The said the Jukta Kishan was shipped to district headquarters hospital Jharsuguda in an injured condition, and the doctor of the hospital referred the matter of the Bulla Medical College. And on the way, the injured, the Jukta Kishan, the deceased, succumbed to the injuries. Hence, the lodged the report.
So there are eyewitnesses to the occurrence.
No, my lord, no eyewitness.
Mr.
Circumstantial evidence.
Mr. Nayak, there are no eyewitnesses to the occurrence.
There is no
Sorry, my lord,
eyewitness.
they just supplied the copy of the evidence, but we don't have
You have not gone through.
that evidence copy is not in the file also.
Deposition judgment same the points.
ଏବେ ଦେଲେ deposition copy
ଆଗରୁ ଏଟା ଦେଖିଲେ but that has not tagged in the file.
ଏବେ ଆସିଲା
ଆସିନି
ଏବେ ବି ନାହିଁ record ରେ ଆପଣ ଦେଖିବେ
My lord, 4 time 4 ଥର ଟାଇମ ନେଲେଣି ଏଇ ଜଜମେଣ୍ଟ 2 ମାସ ଆସିଗଲା
ଡରି ଯାଉଛନ୍ତି ତ କଣ
ଜାନୁଆରୀ 13 ରେ ସବମିଟ ହେଇଛି
who is the doctor, which witness is the doctor?
PW11
The number of the injury in the next of the national fracture and position the head of the disease.
So Ashok, Ashok
She's
Kisan
right.
Bhai,
The eyewitnesses came to stay later. Lucky circumstantial evidence.
My lord, Ashok, the PW 5, 6, and 7 hostage.
You're right. Extrajudicial confession leading to discovery.
No, my lord. Offense of offense, man, bamboo stick and a lathi.
You led the police party to a booth and gave recovery of a bamboo stick. That is number one. That is the position of PW3. Then injuries on the head of the deceased, there was brain hemorrhage. On the left part of the brain, cause of death was due to brain injury.
My lord.
I think that is the public prosecutor is not supported the prosecution.
एवढा not support करते नहीं बोलो hostel hostel इच्छा दे ना
PW8 is the
PW8 देखना
all of the
576.
yes,
576 hostel नहीं जाना
6 hostel.
8
They are the family members of the deceased being examined as 5, 6, 7, 8 have not supported the prosecution.
नहीं hostel declare है ना दे देखो
8 hostel
not
declare
supported but not declared
But anything stated about the offense?
नहीं ଆମେ ନଥିଲୁ ଘରେ ଆସିଲା
I was examined by the police in this case. It is
No, nothing has been stated against the appellant. So the doctor is PW
11.
11.
ଏଇଟା 9 କହୁଛି about leading to discovery
ऐसे जो boost through मिला तो ये था brain hemorrhage, lacerated wound. That report has been marked as Exhibit 6. Exhibitors
interesting ସବୁ support करना दे nobody declared
Exhibit 6.
Sorry. And then shutdown quarrel product the party.
Lacerated wound ଅଛି ଗୋଟେ ଆଉ left scalp ରେ fracture of ଅଛି temporal bone brain hemorrhage. କେତେ ବର୍ଷ ରହିଲାଣି?
More than 8 years.
କେତେ ଦେଇଛି ଗୋଟେ ରାଜ୍ୟ
and temporal ଦେଖ ଏଠି fracture
ସେଟା muscles bone heading ରେ ଦେଖୁଛି ପୁଣି ତା heading ରେ ଦେଖୁଛି
ନାଇଁ fracture of left parietal and temporal base of scalp
next page କୁ ପଳେଇ ଆସ
ଏଠି injuries ଗୁଡା ଦଉଛି Bruises on left side and face.
It has a more detailed description of it.
Lacerated wound on left scap, parietal temporal region, fracture of left parietal and temporal bone.
The effect of the fracture is here.
Left parietal से दीटा region रे हिते से गोटे की दीटा तांको यूरे जाने वाला ଆଉ witness ବି ଏମିତି କହୁନାହାନ୍ତି ଯେ ଅଧିକା ବାଡେଇ ଦେଲା ବୋଲି କହୁଛନ୍ତି
Witness to hostile will direct evidence.
hostile ପରା declare ହେଇନା
Just not
stated by the time we reached the heart
or the land counsel for the petitioner land counsel for the state. The land counsel for the petitioner submits that the petitioner is in judicial custody for more than 3 years. She has produced the surrender custody certificate, which is taken on record. Further submits that as per the prosecution case, the occurrence in question took place on 24/11/2016, and the petitioner stated to have that there was a sudden quarrel between the petitioner and his brother Jukta Kisan, and the petitioner got angry and dealt a bamboo stick blow on the head of the deceased, as a result of which she was shifted to the hospital and succumbed to the injury. The land counsel submits that there is no direct evidence in the case, and the main allegation against the petitioner is based on leading to discovery of the bamboo stick artisan stump on the basis of the statement recorded under section 7 of the Evidence Act. And counsel further submit that the paperwork is not ready and the petitioner has good chances of success in the case. Balance of convenience is in his favor. Therefore, the bail application may be favorably considered. And counsel for the state places the evidence of the doctor P.W. who conducted post-mortem examination, and as you find that the cause of death of the deceased was due to brain injury and hemorrhage due to impact of blunt force oblique trauma on head. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced during prior absence of any direct evidence, the surrounding circumstances under which the occurrence has taken place, the relationship between the petitioner and the deceased, and the period of detention in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed.
Item 7.
My name will be deleted as one prisoner has come. It is not satisfied.
Give another copy is my IN number 291 of 2025. There is an application for bail. How many years you are in custody?
I am in custody since 18/9/2027. 2007 18/9/2007 Then filing the.
Have you got that custody?
May it please before your lordship, I may be permitted to appear on VC.
Yes.
I pray an adjournment on behalf of Mr. Rajat Kumar Panda as he is sick in CRLA number 225 of 2022. Accused Prakash Parida.
Which were the in the other connected matter?
I am in the second item matter.
Yes.
I have pressed my lord for an interim bail on the ground that the wife of the appellant petitioner was on the treatment and in view of her illness, my lord, I have prayed for the interim bail.
Yes, you were asked to obtain instruction on that interim application on 31/2025. IN number 3375 of 24. Mr. Mahanti, Mr. Nayak. CRLA number 177 of 2022. There is an interim application on the ground of ailment of the wife of the
health condition not received. Accident of the six.
No. ଏଇଟା ଏ ଅର୍ଡର ପରେ କିଛି ଆପଣ ପଠେଇ ନାହାନ୍ତି?
ଯାଇଛି ଚିଠି ଯାଇଛି 30th January 25. ଚିଠି letter ଆସିନି.
Get it. IN number 3375 of 24. Land Council for the state submits that as per order dated 31/2025. Instruction has already been sought for to ascertain the ailment of the wife of the appellant and for verification of the medical documents, authenticity of the medical documents annexed to such application, and the matter may be taken up. As you next week now.
Next week.
This matter will be commencing from 17th February 2025. Yes.
Both cases I am appealing for information.
17th 2025. Mr. You are available.
Yes, ma'am.
Land Council for the informant is present.
Ashok Kumar Behra.
Ashok Kumar Behra, A.K. Behra, Land Council for the informant is present. ऊपर पर लिखी दियो तो Mr. You are Mr. R.K. Panda.
Yes, my lord. I am on behalf of Rajat Kumar Panda.
You are Bikram Narayan Das Chaudhary.
Yes, my lord.
All right.
Mr. A mention is made on behalf of Mr. S. Suman, Land Council for adjournment. You to list this matter along with you connected CRLS with us. So I suppose to be
Much obliged, my lord.
Yes.
Item 9.
May I please? If he appeared in custody for about last 14 years, but eyewitnesses are there to do 1 and 3. And in the meantime, the co-accused has also been the co-convict has also granted bail by the Supreme Court.
One IA has been not pressed.
Yes, that I have filed for interim application on account of death of one of the person. But before
on merit your bail application has never
no,
been.
No. For the first time.
And have you handed over the deposition?
Deposition, sorry, I have not.
You don't have also.
I was asked for the staffs of my lord.
No, it's all right. Then why don't you get it? You give your pen drive, it will be given to you. You have got the deposition copy with
No,
you.
I have to collect.
So we are asking Latham.
And ये भी custody certificate as well.
IN number so an application for bail. Mr. Chan and counsel for the appellant submits that he is not having deposition copies with him, and the registry may be asked to supply him the deposition copies from the trial court record in his pen drive. Similar prayer has been made by the land counsel for the state that the registry supply the deposition copies of the witnesses to the land counsel for the parties on their respective pen drives. The land counsel for the state shall also produce the custody certificate of the appellant. Put of this matter we commencing from 24th February.
ଆପଣ ଦି ଜଣଙ୍କ ପାଖକୁ ଯିବ କି ନାହିଁ ଯଦି both the judges available ସେଟା withdrawn କଣ କରିବ not pressed IAଟା not pressed ଦେଖିବ ନାଇଁ interview here not pressed ଥିଲା ଟିକେ standing order ଟା ଦେଲେ standing order ଟା ବି ବାକି ହଁ ନାଇଁ
My lord, my lord, Sahoo and
that we know. That is why we are discussing whether we can hear it or it will go for that bench.
application on account of death of some person, the inmate of.
You were decided about. I'm thinking decided how.
I decided. Application shall be heard. It's my interim bail.
Rejected but decided on the same.
Application for creation bail. Application for interim bail.
This is decided how we have to. To be listed on 24th February 2025. Yes.
Item 10.
Yes, Mr. Roy.
Last occasion, my lord, is call for the custody certificate. Custody certificate was called for in the first item.
First item is JCRL 30.
Yes.
Wait. Let us see.
That is all.
Oh, analysis.
Criminal antecedent
Criminal antecedent तो लिखा है custody certificate का तो लिखा ही नहीं ଆପଣ
both have called
6 ବର୍ଷ ରହିଥିଲେ
6 ବର୍ଷ 5 ମାସ
ହଁ ବାକି କନେକ୍ଟେଡ ଟାରେ କଣ ହେଇଥିଲା
କନେକ୍ଟେଡ ଆଡମିଟ ହେଇନ ଦିଲ୍ଲୀ ଅଛି
ଦେଖିଆ ସେଟା ପରେ
engage me
just a minute JCRL 210 पढ़ा 210 दफा like implement JCRL number 210 of 2025 heard Mr. Saubhagya Ketan Nayak, learned an amicus curiae. Since
one thing I want to draw my lord's attention in jail criminal of 30 perhaps I was the state council
ସେମିତି କିଛି ନାହିଁ ତ state council
ଅଛି ଲେଖା ହେଇଛି SK ନାୟକ
no
orders
ପଢିପାରିବି ଯଦି that is no
nothing
you the state council କେତେବେଳେ ମଝିରେ admit ଯେତେବେଳେ ହେଲା hearing କରିନାହାନ୍ତି ତ hearing କରିନାହାନ୍ତି ତ
the stamp reporter has pointed out that there is delay
of 766
days in approaching in
in this jail criminal appeal. Since the petitioner appellant has been sentenced to life imprisonment, we are inclined to condone the delay. Accordingly, delay is condoned.
So I have also filed a petition
for the trial court report. Yes,
I have filed a petition, delay petition, also formal petition I have filed.
you have filed it.
Yes.
Say module.
22.
Trial court again for you.
Sorry, I number 42 of 20.
Trial court time
No,
already has
no.
call for it.
अच्छा मैंने ये करिया ऐसे जो trial court लिखा है जी since the trial court record is available in the connected JCRA number 30 of 2020
Available nahi hua. हाँ, this year, yes, has been received.
So जितना number के थे IN number
I number 42 of 25.
ये तो call for begin dispose of I already delay on number. So what is your Mr. Roy?
My lord, custody is in more than 6 years and 5 months. There are two witnesses, eyewitnesses. They are PW2 and 6.
You're in custody since 6 years.
Yeah, custody since 6/9/2018.
You have got the deposition copies, madam?
7 years.
I've got the paperwork.
Oh, paperwork is there.
6/9/2018.
देखिए paperwork से
9/2018 तक ऐसे
6 वर्ष 5 मास है ये भी दे दो हाँ ये भी सही
6 years 5 months ये जाऊंगा सेम थे वो
it was never rejected earlier.
Either 2 or 6.
Is there any eyewitness, Mr.
Well, PW2 and 6, madam.
2, 3, and 6.
PW2, 3, and 6.
2, 3, and 6. 2 is the injured, madam.
Just one. PW2, 3, 6. Eyewitness out of which PW2 is the injured.
Injured, yes.
And who is the doctor who conducted PM?
Doctor is 12. 12.
Come to PW2, let us see that.
Well, relevant part I am placing. At the relevant time, I along with my deceased brother had been to Wheeler Munda, Basti, as he had some work in the said village. While returning, both the accused person abused me and my brother in Hindi language.
Both means so both money wrong.
My lord, deceased and this petitioner. This is PW2.
Just a minute. How many persons were facing trial?
2 persons.
2 persons.
Yes.
Both yes.
Both yes.
Abuse.
Thereafter, both the accused person dealt fist blows to me. When my deceased brother intervened, both the accused person dragged him down and assaulted mercilessly by dealing fist blows and kicks. Out of fear, I ran away from the spot to call my sister-in-laws, Okkali Devi and Madhuri Devi. We three then went to the spot. We found the accused person were assaulting my brother by means of stone on his head, face, and chest. Seeing us, the accused person fled away from the spot.
Similar evidence is there from
similar 3 also and 6 also.
How many days after he died?
My lord, when he was shifted immediately, my lord, the doctor declared him dead.
And what are the injuries?
Injuries, my lord, there is only 2 injuries as per PW12, my lord.
Page 60.
And you see, deep brown lacerated wound over the right parietal bone, a deep brown color lacerated wound over the right temporoparietal bone.
These are external injury.
Yeah, these external injury, and the injury was caused by stone two stone was seized from the spot. Though blood was found from the stone, but it was not matched with the deceased blood group, my lord. And in the gauge,
It did not match means it was not enough to that deteriorated. That is why it did not match, or was different blood group.
no, the chemical examiner report says the blood group which was found from the stone is B, but to prove the incident, my lord, the blood group of deceased along with the blood group found from the stone was not matched.
Again, I'm asking, did not match in what way?
No, they have not collected the. This is the chemical examiner report says.
Where is it?
That is, my lord, kindly see.
Page 74.
That is page 74 and 76. 76, your lordship may see. Human blood stain of B group was detected in the exhibits marked as A, B, C, D, E, H, I, and N. D is the stone and E is the stone. Then, my lord, blood stain of human origin was detected in exhibit marked as K. The blood group would not be opened due to degradation. Then, my lord, origin and grouping could not be opened in exhibits marked as L, Q, and V, that is sample bloods, due to preserved in moist state decomposed.
It is not a question of not matching. It could not
Yes,
be tested.
yes.
Yes, there's a difference.
Because of the.
Yes.
And there is also no weapon was used. The stone which was lying on the road, my lord, that was.
No, it is not suddenly you assaulted. You kept assaulting, fist blows, kick blows, that would have been enough. But then you picked up the stone after he fell down.
Undue advantage kitchen.
There is no injury on the leg.
No.
There are two injuries on the skull itself. Page 65.
Page
No,
65 of what?
65 is the
And doctor also says that the injury.
deposition of the PW12 was the conducting field.
No, madam, your witnesses have stated PW2
Yes, sir.
that the stone blows were given by both the accused
Both the
persons
accused.
on the head, face, and chest.
Yes, sir.
So, if two accused persons were assaulting with stones repeatedly on the head, face, and chest, what are the injuries noticed? There are only two
Kindly
injuries.
see page 65.
65.
Page 65
Yeah.
of the paper book.
There are two external injuries.
No, there are four injuries. There are two internal injuries who were fatal.
Two?
Out of four injuries, two were fatal and both are in the skull. Internal injuries. Lacerated. May I read you?
These are the two parietal region रे
Yes, sir.
दुईटा lacerated wound अछि बाकी abrasions अछि आउ कोन अछि injury
Fellowship, so may I kindly see cross-examination paragraph 4, your lordship, of that witness. The death was due to injury number 1 and 2 as per exhibit 8. The 1 and 2 is in the skull, the internal injury caused by the stone, your lordship. I'm placing the deposition of PW12 was conducted at the postmortem.
And cross baby Sukoji, the injuries by exhibit 8 are possible by accident fall on hard and blunt surface.
And there are three eyewitnesses and they're corroborating each other.
No, you are right, but
there are two injuries in the skull itself.
Because chest injury is not there, and leg injury is not there. Though the allegation has been leveled that there was also assault on the chest, and PW6 has stated that on the leg also the stone blows were given. PW6. So, in that way, there are discrepancies. Otherwise, those have to be adjudicated at the time of trial. Now, this first of all, they assaulted by means of kicks and fist blows, and then these injuries were caused. Two injuries mainly.
How many years in custody? 6.5.
6 years. And no criminal acts.
Counsel for the state. The land counsel for the petitioner submit that the petitioner is in judicial custody for more than 6 years. And there are 3 eyewitnesses to the occurrence, that is PW 2, 3, and 6. And as per the evidence of the eyewitnesses, the deceased was first assaulted by kicks and fist blows, and then it is stated that 2 accused persons, including the petitioner, assaulted by means of stone on head, face, and chest. However, the doctor has noticed mainly 2 external injuries on the head, which are lacerated wound, which according to the doctor were antemortem in nature, and the cause of death was due to neurohemogenic.
So 1 and 2 are internal injuries.
1 and 2.
Internal injuries.
Which one?
Put a 1 and 2.
1 and 2 are internal injuries, not external.
Madam, external injury heading the DIC. कौन पूछेंगे?
External ଲେଖା ହେଇଛି।
Can you see the internal injury?
अरे ता परे इंटरनल अछि एगुडा एक्सटर्नल
तार इफेक्ट होची इंटरनल
Internal.
ता परे इंटरनल दीटा अछि
Yes.
6.5 years we are not giving now.
So and so new on the cause of death was no point of neurohemorrhage due to injuries. So and so. The land council further submit that there are good chances of success in the case. Balance of convenience is in its favor. Therefore, the bail application may be favorably considered. Land council for the state place the evidence of PWs, the eyewitnesses, so also the evidence of the doctors. Considering the submission made by the land council for the respective parties in view of the nature of evidence available on record, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody, we are inclined to release the petitioner on interim bail for a period of 3 months below. In view of the available material info, we are not inclined to release the petitioner on bail. The preparation of the paperwork has already been prepared. The matter be added to the hearing list. It is 17th of March 2025. Yes.
Should I collect a paperwork?
Yes, yes. The Mr. Nayak be provided with the copy of the paper. Yes.
Item 11.
Yes.
Lordships, I'm appealing the judgment dated 29 January 2024, wherein the appellant has been convicted under Section 302 for life. The name of the deceased is Namita alias Amita Mukhi, who is the wife of the appellant, Your Lordships. The prosecution story is that on 20th
You
of
have
September,
received the position copies? Yeah.
Paperwork is there.
And it's all right. What is the allegation?
Allegation, Your Lordship, is that on 20th 9 2020, the 2020, the at around 10 o'clock, the husband and wife, that is the deceased and the present appellant.
You have killed your wife?
Lordships.
Okay.
They had an altercation when he went to get certain things from the house, and in a fit of anger, he took a knife from the house and stabbed the deceased around the chest area, Lordships. She was immediately taken to the hospital, and there, after she received treatment, she came back. But then again, on 26th of the same month, she was again taken to the hospital, where she succumbed on 28th.
So the date of occurrence is
20th of September 2020.
And date on?
28th of September 2020.
Okay. A stab blow on the chest.
Chest, your lordships.
By knife.
Knife, your lordships.
So
The
eyewitness
two eyewitnesses are there.
Who are they?
Lordships. Eyewitnesses PW1 and PW4.
The daughters of the.
Daughter.
One person is the daughter. PW1 is the daughter.
Four is the niece.
PW4?
PW4 is the niece.
Niece.
Lordships. PW1, there is a slight discrepancy. She was declared hostile and then she was cross-examined. But with regard to why she was declared hostile was, she said that on that relevant day I was not present. In the chief, she has said that I was present. During the cross-examinations, she said that I was not present. I was staying in Bhubaneswar. And then again, when she was declared hostile, she again clarified that.
But about this assault or stabbing by on the chest, that she has stated.
That's yes.
Not only PW1, but that PW4 has also stated.
That she stated, PW1, what I'm trying to say, Your Lordship, is PW1 stated, I was present, I saw the occurrence in the chief. Your Lordship will find it. I'll point it out. Starting at page 41, Your Lordships. May I please?
Yes, sir. That is there within the chief examination, it is there.
Lordships. But then again, in the cross, Your Lordship will see at para 7, page 45.
Paragraph 7.
Lordships. The incident took place on 29/2020. At that time, I was staying at Bhubaneswar. Pardon, Your Lordships. I may be pardon, Your Lordships. Para 3, page 43. Fourth line, Your Lordship. My mother was staying at Bhubaneswar with my two sisters. On 20th/9/2020, I was in my village. I got telephonic message from after 1 or 2 days of the incident. I reached Bhubaneswar after 2 days of the incident. So this she has stated in the cross-examination. Person to which she was declared hostile. And then she has clarified. Which I pointed out, para 7.
Paragraph 7.
Lodged.
At SCB Medical College, on inquiry of the doctor, I stated that my father has stabbed my mother.
That is a consistent case, Lordships. I will not.
The incident took place on Shantu. At that time, I was staying. Okay, what about PW4?
PW4 has reiterated everything, Your Lordship. Same thing, same story. That at night he had come and then everything has he has.
Be the doctor who conducted.
Lordships. There is the medical. This is the case of medical negligence. Lordship will see page 65.
No, who is the doctor first?
PW7 is the first she went to. PW7.
No, the PM doctor.
PM doctor is Lordships PW8. PW7, when she first went after the injury, she is only cited to have one Lordships page 65.
Left side chest, 1 inch.
1 inch to half inch to half inch.
I have referred to the surgical specialist. Okay.
And your Lordship will see at page 140 and 144. She has just prescribed medicines and some ointments and then let her go. Then again, your Lordship will see page 69, which is the PM doctor who conducted the postmortem. He has given 2 injuries, your Lordships.
One is a bruise and the other is.
Lordships. The second one is.
Lower angle of the left scapula and opening of swanson. Green margins and dissection I found that there was a punctured sound on the left lobe of the lungs. They opened the puncture. It was by sharp penetrating weapon and suicidal intention.
But PW4,
Lordships,
there is no provocation. You just came, asked for a cap and ganji. When she came, you stabbed her.
Lordships. Provocation has been referred to in the FIR, so also the PW1.
No quarrel, nothing.
Lordship will find it in PW1. Page 41, first para itself. May I place, Your Lordships? Your Lordships. I'm placing from the start. I am the informant of this case. The accused Rajendra Mukhi is my father. The deceased Namita Mukhi is my mother. She is also known as Amita. The incident took place on 29/2020 at about 10 p.m. At that time, we were staying at Birsa Munda Basti. My father always quarrels with my mother as he has extramarital relationship with another lady, Bharati Naik, who is the elder. On 29/2020 at about 10 p.m., my father quarreled with my mother and stabbed her under the chest inside our house. In the FIR also, she has stated the same. And that is the consistent case of all that she used to come and they used to quarrel, and that quarrel part is there.
Consistent case, who else has stated?
Your Lordships, the other witnesses, post occurrence witnesses, that is PW26, they were always fighting.
They're fighting because of his extramarital, not her fault.
No, not her.
You exhibit 8 ଯୋଉଟା ଦେଖୁଛି ଯେ ସେ ଲୁହା ଛୁରୀର ଲମ୍ବ ହଉଛି 7 ଇଞ୍ଚ,
ଆଜ୍ଞା,
ଯାହାର ବେଣ୍ଟ ହଉଛି 3 ଇଞ୍ଚ, ତାର ଇଏଟା ହଉଛି 4 ଇଞ୍ଚ. ଏଥିରେ ଆପଣ you inserted on the a place that is a vital part of the body, and the injury is that deep is entered into in centimeter ଭିତରୁ ଯାଇଥିଲା.
Again, the chemical examination report, Your Lordships, it could not, the blood could not be, it could not be done because Your Lordship will see page 103. Degradation by it could not be done.
It is sufficient in ordinary course of nature to cause death.
Lordships.
Question is that if this evidence is accepted, and let us say that you establish that there was some kind of quarrel or the grave and sudden provocation, then also it would go to 304 part 1. But, you are remaining custody
4 years,
for 4
6
years.
months.
So
my contention, that was by contention, Lordship, was going towards medical negligence, because when she saw the injuries, if she was treated at that appropriate stage, she could have suffered.
no, that goes against the you have you seen that 299 dedicated IPC, which is now
One thing is that. Second thing, had you taken her for treatment also, we could have understood.
Lordships.
There's a lot of these 304B cases.
299 IPC.
Lordships, I have the book.
Come to explanation 2.
May I please? When the death is caused by bodily injury, the person who causes such bodily injury shall be deemed to have caused the death, although by resorting to proper remedies and skillful treatment, the death might have been prevented. Of course, I know where I'm heading, Your Lordship, but I have to make out a case, Your Lordship.
No, it's all right, but stay some for more time.
That is the reason I was relying on this latest judgment which has come across, which only says where there's a single injury.
No, single injury. One
I understand.
ବାହାରି ଗଲେ ତାପରେ convert ହେଇଗଲା ଆଉ ଆପଣଙ୍କୁ ଭିତରକୁ ଆସିବାକୁ ପଡିବନି.
I guess that we get.
4 ବର୍ଷ ଆପଣ ଯୋଉ ରହୁଛନ୍ତି,
the period is too less for Your Lordships to consider. That is, of
Single
course,
injury also, body, lathi, picked up something. It is joda khale 7 inch.
7 inch, it is from the house itself, Your Lordship. It is not that I took it. Let the bail be lie over, Your Lordships.
After arguing for some time, Land Council for the appellant seeks for an adjournment of this matter. Yes, next.
Oh, pleasure, Lordships.
Mr. Panda is there.
Super item number 5.
We have engaged him, or what how Mr. Panda was engaged in this case.
But let me check. Engage କରିଛନ୍ତି court 9/9/2016.
No, 11/2023 ଆମେ engage କରୁଛୁ ଆଙ୍କୁ Mr. Panda.
ତାହେଲେ ଆଉ ଥରେ
हाँ तब से बाहरी गले से काउंसिल ଆସିଲେନି
नहीं 9/9/2016 रे पूरा रिलीज
से हम अन्य केस एन पटनायक को ଦେଇଥିଲେ
नहीं 9/9/2016 मिस्टर पंडा
अंडा ଥିଲେ ଯେ ତାପରେ
कोर्ट
से
रे थिले ओहो पुणी आउ थरे हेले
ପୁଣି ସେ ବାହାରି ଗଲେ
अच्छा अच्छा
ତେଣୁ ସେଥିପାଇଁ 28/8/2023 ରେ 29/8/2023 ଦେଖ
से 8
29/8/2023
ओहो आस कोर्ट रे आसु नथला बोली आ जण का तापर पळे आस्थिबे
ପୁଣି ନାଇଁ ନାଇଁ ପୁଣି ସିଏ ଆସିଲେନି ସେ ଯୋଉ ଆର ଜଣକ
ये आसिले तापर
ସିଏ ଆସିଲେନି ତେଣୁ ଇଏ ମିଷ୍ଟର ପଣ୍ଡା ଆସିଗଲେ ତେଣୁ ତାଙ୍କୁ ଇଏ କରାଗଲା ତେଣୁ ପ୍ରଥମ ହଉଛି ଯେ also ଦିଟା ଡେଟ୍ ରେ ମିଷ୍ଟର ପଣ୍ଡା was present and the presence
9/11 पळे आइले हां लास्ट डेट रे भी से थिले
हाँ ଥିଲେ
आ गुटे डेट दे
you just intimate Mr. Panda that non-appeals କରିଦିଅନ୍ତୁ matter be listed weeks up to the date ଦେଇଦିଅନ୍ତୁ yes
एकदम 5 पर
somebody was there
एबे आ गुटे मार्क डाकु जंदी कोर्ट अच्छा
फोन करियो ना तो दो नंबर पे
Item 13.
13 and 14
one K.
Item 14.
Please, madam, I file on IA for bail.